Lordship. My lord, the petition was filed today, Lordship. My lord, the petitioner, my lord, applied, my lord, under backlog vacancy, Lordship, my lord. The merit list was prepared, the petitioner's name was not, my lord, considered, Lordship. Now tomorrow stated that the post is going to be filled up, Lordship.
Friday for motion.
Tomorrow is the, my lord,
No, if it is done without proper procedure, it will be set aside.
Lordship. Right.
My lord, item number 30 may be passed over, my lord, today.
Item number 30.
30, man. 30.
Item 30 is a part of series. You wait, we'll pass an order.
I'm not well,
It is a part of a series. You wait, we'll pass an order.
I'm not well, my lord.
Rejected. Next matter, please.
May it please your lordship. I am the writ petitioner. I'm under infant protection. A 223 application has been filed on 31/5. The time has started. May I pray sometime within the 14 days period, my lord, at the earliest possible.
Which matter you are mentioning?
So this I'm mentioning an application under Article 226(3). I'm for the writ petitioner. They have filed. Otherwise, that 14 days time would come in, my lord. It's 31/5 they had filed. So today it's around 6th.
Next week.
Within the time frame. only.
Yeah, please, lordship. Lordship, I have filed the writ petition on 3rd June, my lord. So I'm bringing for the listing for tomorrow, my lord. This is a transfer matter. He has completed only the 11 months at the present place of posting. He is about to release by tomorrow, my lord.
You should have come earlier.
My lord, I have already filed.
Tomorrow this bench is not available. And I don't want to fix. matters
Otherwise,
for
he
it.
will leave, my lord. Then,
Friday you take it. Thursday you take it. Thursday.
my lord, tomorrow, if possible, my lord.
Then you go and mention before the other bench. This bench is not available tomorrow. For motion. You go and mention. Yes.
May be, lordship. Also, I like to mention for listing on tomorrow for Weddell, lordship. Weddell, tomorrow, lordship.
Lordship, I beg to mention item number 17, my lord. Mrs. J.D. Count, who is conducting the case, is in out of station for her. doctor's-
Mr. Series matters individually will not be adjourned. You know the rule. When the matters are called up, we will accommodate everyone. Yes, it cannot be adjourned. Don't even make a mention like this.
Lordship, my mention item number 10, Lordship, my senior is not well.
All right.
So,
rejected.
matter
Next
may
matter,
attend for-
please.
Maybe not. I beg to make a mention for listing, your lordship. Maybe Friday as per your lordship's
What
convenience.
matter?
The matter pertains to the displacement of the petitioner
No, is it for motion?
for motion.
Friday.
I'm grateful.
Yeah, please, Lordship. Lordship, I beg to mention a pending writ petition. Lordship, it is a service matter regarding a recruitment. Lordship, although the petitioner had the required educational qualification, but he was not given a chance to appear in the departmental examination. Lordship, there is an interim protection that out of the 5 posts, 1 post would not be filled up till the next date. Lordship, this matter was last listed on 1/3/2023, but the
You are
response,
for whom? You are for?
I am for the petitioner.
So there is an interim order.
There is an interim order, Lordship, but the respondent author is taking a lot of time to file their affidavit. So, Lordship, may the better be listed.
4th week of June. 4th week of June.
By sincere of my lord. Can it be on Thursday, my lord?
Yes.
My lord.
I should prayer for listing, lordship, content case 408/2020, lordship,
Sorry?
408/2020, lordship. The petitioner is getting fixed salary, but she has to she has prayer for a regular salary, lordship.
I've not understood anything. You want adjournment?
No, lordship, prayer for listing, one content case 408/2022.
4th week of June.
God bless.
May I please, lordship? I beg to mention for listing, my lord. This is a commission and appointment, my lord. This is my second time application, my lordship.
4th week of June.
My lord.
4th week of June. 4th week of June.
Oh, mass application.
For addition, item 1.
My lord, may I pray this matter may be taken up after 12th lordship.
No, this is 2017 matter.
Lordship,
See,
that
these are cases, old matters. We are having
Lordship.
problems in the system.
lordship,
So there will be no adjournment in these cases.
that issue has been
And this is
decided by
lordship
the Supreme Court.
2012 recruitment.
Yes, lordship, that issue has
Otherwise
been.
also not, sir.
So sorry.
Sorry.
Can argue
Okay.
today. I
Lordship,
can
that-
give you half an hour time to prepare, but adjournment for asking will not be done.
Lordship.
So sorry. That is a decision we have taken. We are not Because these old matters are languishing. Adjournment after adjournment, this is not going to work out. Half an hour. After half an hour.
My lord, item 3 may be taken up first, my lord.
May I please, Lordship? Lordship, in this matter, pleadings has already been exchanged, Lordship. Lordship, another matter is also pending, Lordship, WPC number 2514 of the 2020. Lordship, let all the 3 matters may come for next week or the other day, Lordship, for hearing. Lordship.
What are these matters about?
My lord, whatever here, these are all concluded matters. Division,
These are all?
concluded order was passed by division bench, my lord.
Hmm.
Regularizing our service with effect from 1997 and directing them to pay all consequential benefit which we are entitled to with effect from date of regularization. Now they have regularized our service and thereafter they are required to pay the consequential benefits. Some benefits they have paid, my lord.
Where is the order?
Order of regulation, your lordship will see.
No, where is the order of division bench?
Yes, Lord.
Page 26 is the
You are referring to item number?
3, my lord.
Yes, page number.
Page number 20, my lord. Annexure 1. And the relevant portion, page 26, my lord. Page 26, may I read it, my lord, last 4 lines?
Yes, page 26.
Yes. Accordingly, the respondent authorities are directed to regularize the service of the appellants from the date when the last of the 11 candidates were confirmed or regularized, and all consequential benefits of being regularized be provided to them from the said date. The aforesaid be done within a period of 3 months from the date of receipt of certified copy. Now pursuant to this, my lord, next page, your lordship, they sell this order before the Honorable Supreme Court. Now, page 27, and their special leave was dismissed, my lord, by upholding this order. Now, thereafter, my lord, at page 28, they passed the order of regularization, my lord. Regularization is page 28, my lord. Order dated 7/1/2019. By this order, my lord, each of the writ petitioners, my lord, they were regularized with effect from 13/5/1997 as housekeeping, post of housekeeping attendant, grade 1, in the scale of pay 10,500 to 24,500 with benefits accrued thereof on the following terms and conditions. And this order was passed by the, my lord, General Manager HR.
Then what is happening?
Thereafter, my lord, what happened, my lord? While paying the page 35, if you lord, you will see the consequential benefits, my lord, which was, my lord, accrued, my lord. There was a contempt or, my lord, petition filed thereafter, my lord. Since it was not paid immediately, my lord, the contempt petition was filed, and in contempt petition, my lord, though they have annexed that order, my lord, there is an order for them to
Page number?
page 35, my lord. This is the breakup of consequential order, my lord. Pursuant to the contempt order, my lord.
Contempt order is page 37 of our affidavit in opposition.
No, it's mentioned here, my lord.
But I have
In
annexed
our
the
page 35, it is
lordship order.
mentioned. If I read that order, my lord, order dated 7/1/2020, breakup of consequential benefit on regularization. Further to our letter number so and so, in connection with the above subject matter, Honorable High Court by order.
Yes,
dated-
34,39,762. Yes, then what has happened?
Now, what happened, my lord? In our affidavit, my lord, we have stated that as per, if your lordship will.
Have
please
you
to-
received this amount, 34 lakhs?
Yes, that is received.
Then what?
Now, as per the entitlement,
Hmm.
there are certain, my lord, rules, circulars prevailing.
Hmm.
They have not considered our promotion
Alright.
as per.
And which is
rules.
the other WPC? Yes.
Lordship,
Take down, heard Mr. B. Borwal and counsel appearing for the rate petitioner in both these petitions. Also heard Mr. M. Kalita.
K Kolita.
K. Kalita, Lanis counsel appearing for the Indian Oil Corporation Limited, who submits that these matters are ready as regards pleadings. However, a similar matter being WPC number 2514 of 2020, which is pending before this court, has not been listed today. In view of the above, register to list these cases along with WPC number 2415 of 2020 for admission hearing on a non-miscellaneous day after 2 weeks.
My lord, can it be on a date, my lord?
After 2 weeks, non-miscellaneous.
My lord, we only seek a direction for entitlement.
Yeah.
Please.
Please, your lordship. I am appearing on behalf of Mr. H.K. Das, my lord. He's on legs in another court, my lord. May pass over a matter for
No,
time.
you argue, what is the case? Let us see.
Lordship, in fact, the case brief is also with him, my lord. I'm sorry, my lord. After a while, my lord.
What is this matter about?
My lord, on behalf of the state respondents, my learned will argue, my lord. I'll say, my lord, argue only one and same, my lord.
Lordship, in 2012, Lordship, government issued one notification that for promotion to the post of grade 3, Lordship, minimum qualification required is graduation. And that is his prayer that should particular office notice, Lordship, should not be make applicable to him. That is his only prayer, Lord.
On what ground he is making that prayer?
Lordship, he has not made submission on that particular issue, Lordship, at all, Lordship. He is.
So we'll pass over for the time being. Next call, we'll take it up.
Wait, please, your lordship. There are some subsequent development, my lord, in this matter, my lord. I need some time to bring those local documents, my lord.
Yeah,
Report,
just
my
a
lord,
minute, just a minute.
from filing additionally with you.
Yes, what is the instruction?
Your lordship, I have placed one OM, the government personnel department,
Hmm.
with regards to the seal cover procedure as to when it will be adopted.
Where you have given it to?
I've placed, I've given to port master. 5.
Yes.
If your lordship goes to paragraph number 2.
Hmm.
Subpara 3. Government servants in respect of whom prosecution for a criminal charge is pending.
Hmm.
Your lordship, in this regard, my respectful submission would be even initiation of a FIR.
So it is there.
My lord, the prosecution sanction, my lord, was granted in a particular case, my lord. That case,
All right, you want to file affidavit?
my lord,
All right.
my lord, that
Heard
case has been
Mr.
disposed of, my lord.
Learned Counsel, huh?
That case has been disposed of, my lord. That is why, my lord, I want to bring that order, my lord.
Mr. S. Hawk Learned Counsel appearing for the petitioner also heard Mr. D. Bora Learned Government Advocate Assam, who is obtaining instructions in terms of the order dated 0106 in 2023 passed by this court in the present proceeding and has produced a copy of the OM dated 9/5/2006 to submit that. Seal covered proceeding is permissible even in case of those government servants in respect of whom prosecution for a criminal charge is pending. Mr. Responding to the above, Mr. Hawk submits that there are certain subsequent developments in this matter which are required to be brought on record by filing affidavit and hence 3 weeks' time has been paid for.
My lord. Next,
Prayer allowed, let this matter be listed again after 3 weeks.
my lord.
Revenue Department.
Mr. J. Henry, I am standing counsel, Revenue Department case pending. On behalf of respond number. You have for respond number?
2 and 3 lordships.
Respond number is 2 and 3. Mr. Bora for 1.
Okay, additional affidavit file.
Item 6 to 41.
Yes, these are all compassionate appointment cases
My lord,
which are rejected on the ground of delay.
my lord.
Now, what is the stand of the government? Instead of taking these matters in piecemeal manner, what is the stand of the government? There are 3 different aspects of this case. Number 1, we have seen that applications have been filed after much delay from the date of death. Secondly, applications filed within time, but the DLC and SLC took a long time to consider and reject the same. More particularly the DLC. And number 3, even if those cases in which delay has happened due to non-consideration of the application by the DLC within time, what is the remedy today available, because the scheme has already been withdrawn?
My lord.
What is your stand on that?
My lord is taking up this matter for disposal today, or my lord?
We normally take up matters for disposal, not for keeping it pending, unless you have objection.
My lord, if you go by the delay part, my lord. My lord, this state of West Bengal versus the brother Tiwari, the latest judgment that is there in my lord's that file, my lord. It is there. We have placed it, my lord. There, my lord, the Honorable Supreme Court has taken a stand that, my lord, that whether after a prolonged delay for whatever reason, my lord, does it, my lord, meet the object of compassionate appointment?
No, but why have you been sitting over these applications? DLC sits over these applications for 6 years, 5 years, 4 years. Why?
My lord, what? My lord, so far I have talked to the people, my lord. They say that if my lord, what happens? Only 5%. So unless we have 20 vacancy, we cannot carve out one post. For
But then why do you recommend? Why does the DLC recommend then if there is no vacancy? First you recommend. Do you recommend without ascertaining the vacancy position?
My lord, these few points, what my lord has just fallen from my lord's mouth, my lord. I will try to take this answer from the government regarding queries, my lord. And my lord will fix this matter for final disposal after the vacation. Once my lord has even asked our additional advocate general D. Majumdar to appear in this matter also.
Where is he?
Today, my lord, he is not in this court, my lord. He is indisposed. He is out of station, I am told. But my lord, this queries, it is very important, my lord. I will get this instructions from the department and the stand also. We will, my lord, deliberate on the law also. What is the, my lord, our stand? And I will try to get, I will file one common affidavit for all on this particular grounds.
See, Mr. Dhar, the cases where applications were filed after delay, they cannot be equated with cases where applications were filed within time, but the DLC set over the matter or SLC set over the matter and rejected it after a long delay on the ground that the application is barred by delay. There, can we apply this principle that compassionate appointment urgency is over? This will be an engineered way of defeating applications in a pick and choose manner.
Yes,
You
my-
decide, we'll sit over this application, his claim is
yes,
gone.
but
You
my lord,
promptly act on somebody else's application,
My lord.
he gets it.
and my lord, I have gone through some matters where there was no 5%. After a span of 5-6 years, they have come to conclusion that there is no vacancy. Means, my lord, the 20% that 5%, my lord. There was not 20 posts available at that point of time. So we could not carve out one post out of
No,
that.
but then why did the DLC recommend their case? Is the DLC not required to look into the vacancy position?
There are few cases where DLC has been rejected also, my lord. We'll make a chart, my lord, for this also. We'll segregate it.
All right, now the petitioners council, perhaps you have nothing to say today. Let their stand clear. Then we'll
Both
I can
item
consider.
15.
Learned counsel for the respective petitioners are present. Mr. Ardhar, learned additional senior government advocate, along with the standing council of respective departments are also present. In these bunch of these read petitions have been bunched together on account of the fact that in all these petitions, the application made by the respective petitioners seeking appointment on compassionate ground have been declined on the ground of delay and stuff. In some of these petitions, there was delay on the part of the petitioner in submitting the application for compassionate appointment after the death of the government employee, either on account of the fact that the son, stroke daughter, stroke ward did not attain majority at the relevant point of time, or for any other reason. However, in a majority of the cases, this court has noticed that applications were submitted within time, but the district level committee, DLC, sat over the matter for a long period. When the recommendation of the DLC was forwarded to the state level committee, SLC, those were rejected on the ground of delay by urging that the purpose of providing immediate relief to the victim's family, to the family of the government employee was lost in these cases. This court has also seen that the DLC has made recommendation in a number of cases which were finally rejected by the SLC on the ground of want of vacancy. From an analysis of the stand of the department, DLC, SLC in a number of matters, this court has noticed that there is total inconsistency in the stand of the respective bodies, in the stand of the respective committees. Whereas in some cases, applications for appointment on compassionate ground have been acted promptly, in some others, there was enormous delay in consideration of the same. It is also not understood as to how those applications forwarded by the DLC would be turned down on the ground of want of vacancy when the recommendation of the DLC itself was against a particular vacancy available in the department. The lack of clarity in these matters has envisaged incessant flow of writ petitions to this court, wherein the petitioners have approached repeatedly seeking the same relief, and the orders passed by this court have been discharged on one technical ground or the other. Situated thus, this court is of the opinion that more clarity is required in the manner in which the SLC and DLC is functioning in these cases. Mr. Dhar, learned additional senior government advocate Assam, has sought adjournment in these matters in the ground that Mr. D. Majumdar, learned additional advocate general Assam, representing the state in these cases, is not available today Full stop. He has also assured this court that a common affidavit addressing the issues flagged herein above shall be brought on record within 2 weeks from today. In view of the above and on the request of Mr. Dhar, these matters are directed to be listed again on 27th of June 2023 as fixed item. The affidavit on behalf of the state shall be filed within 23rd June 2023 by serving copies upon the counsel for the petitioners in all these cases. Full stop. Let us see, we'll thresh it out.
The affidavit should come, what has Lordship has already observed. On that particular point, they have to file the affidavit, my lord.
You have probably not heard. That is the reason why they are.
Yes. This is it.
My lord, 42, my lord, I am appearing in 42 item number. It's one of the oldest case of the Guwahati High Court petition. Your lordship kindly, my lord, straightway goes to, matter was simple, my lord, but make it complicated, and in spite of the repeated request from this honorable court, the department, my lord, playing with the court, my lord. I'll place, my lord, your lordship kindly straightway goes to my lord, your lordship kindly see, my lord, order dated, my lord. 7.
There are other 3 matters also. Lord. Yes.
No, I am not concerned with the other matter, my lord. I'm
All
placing-
under tag together.
not tagged together, they had different. And in fact, my lord, their points are different. They are afterward file this petition, my lord. The fact of the case is that we are selected, I am selected candidate, below me were appointed. Below me were appointed. 7-8% below me, they are still continuing, they are going to be retired. Even I am yet to be appointed, my lord. And my lord, in fact, that select list was declared illegal by this honorable court. But that illegal is still continuing. There are series of cases, my lord, but still they are continuing, my lord. That's why I am not going to that, my lord. Your lordship kindly see the order dated 4/9/2017, my lord, of my petition, my lord. Four 9/2017, order dated, my lord.
Yes.
4/9, my lord. The respondent authority submitted that they have decided to prepare to submit a fresh proposal to accommodate the petitioner as well as the private respondent in the post of extension officer. The submitted the abide order dated 3/5/2016, passed in IN number 20. This court has given liberty to the respondent to consider the regulation of the service of the petitioner as well. Then your lordship kindly see next order, my lord. 6/11/2017. 6/11, my lord. Standing Council of the Industry Commerce Department submitted the department authority are in a process of preparing a scheme for regulation of candidates who were appointed in the year 2022. Also, at least the such schemes could also have same favorable implication in the candidate appointed in 1995. Then your lordship kindly see order dated 28/2018. On
So,
pair of
Mr.
the
Nando, let us hear the case. This
My
has
lord.
come for hearing, let us hear it.
my lord.
Let us hear the case.
No, my lord, why I'm pointing that order, my lord, in pursuance to the order, my lord, they have to file in fact, there is a personal appearance of the industry department, my lord, commissioner. In spite of that, my lord, they have not filed a affidavit till today.
Then we'll dispose of the matter on the basis of materials on record.
No, my lord, whether they are going to, my lord, comply, because they have,
Oh, Mr. Mahanta, we can't go into all this. This matter is listed for hearing. You argue your case, he'll argue his case, we'll deliver our judgment.
my lord,
Yes. What they will do, we don't need to take their consent. These are not tag matters according to you.
My lord,
These are not connected matters according to.
others are, others, my lord, what, some of the them, my lord, they are, my lord, not even selected, my lord, they are in ad hoc basis, they are continuing, and they tag with my case, my lord.
Actually, Lordship, what has happened is there a same select list, Lordship, same select list is under consideration.
My lord, there's the advertisement that was published in, my lord, Annexa 1, my lord, page 25.
That is 30/11/1993.
My lord. 30/11/1993, my lord. In pursuance to that, my lord, there two selection lists were prepared, my lord. Your lordship kindly see page 26, my lord. Serial number 80 is the petitioner, my lord. Serial number 80, my lord.
So this advertisement is for quality control examiner.
My lord.
This advertisement is for quality control examiner.
My lord. Extension officer also. Appointment of extension officer, my lord, in the office of the director of industries, my lord.
All right, yes. Then what is
Petitioner is a selected candidate, my lord. So this heat petition, my lord, these are the two, my lord. These two, my lord, select list was prepared. And in both the select list, petitioner names were there, my lord.
Serial number?
Serial number 80, my lord, is the petitioner, my lord. Tilok Nath. Serial number 96, respondent number 9. Serial number 99, respondent number 6.
Yes. Yes, then what happened?
And serial number 104, respondent number 7. Serial number 109, respondent number 8. And serial number 149 and respondent number 10. So they are made party, my lord. So from this select list, my lord, on pickup basis, they are appointed, my lord, but some of the candidate, my lord, they oppose this honorable court. Then this honorable court, my lord, declared it illegal and entire select list was set aside, my lord.
Where is the order?
That is, my lord, your lordship will find. I'll read it. Page. This start from page, my lord, 49. Your lordship will page 54, my lord. May I read the judgment, my lord?
Just 1 minute.
Page 54, my lord.
Yes.
So, may I read the judgment? All this matter raised is simple question of law and fact. Hence, they are taken together for disposal. An advertisement was issued in 28/11/1993. Fill up the different post of thereafter the select list of 150 persons were under made on 22/3/1995. It is the illegality and validity of this process of selection is selected list, which is challenged. In the meantime, the department authority on its own instituted an inquiry in the matter and reported that report was submitted holding the selection appointment was not to be fair. Since the inquiry report of the Secretary Government of Assam Industry and Department with regard to the matter, from the report, it is seen that the whole selection and process, it was hence, and in the whole process, nothing but striking. The inquiry report has been produced in record now, with copies of the copies to the parties. Mr. S. Roy Lane, advocate of the respondent number 2 and 3, civil libel number so submit that the person have been selected in excess for no vacancy exists in the department. A selection was made without any norms, but according to his whims, press advertisement shall be issued indicating the numbers of available vacancies in selection shall be made in accordance with the prescribed procedure. The persons who have already in the list have applied pursuant to the fresh advertisement shall also be given an election of necessary. The court has passed this order in appears that the earlier selection was absolutely a France and nothing but monkery and found to be department throughout its own inquiry. As a matter in fact, the selection is as appeared so and so. A person cannot be appointed on the basis of this such selection to hold this responsibility post. So these
So
are
select list was set aside.
absolutely, my lord. Your
Where
lordship.
where is the order? Which page?
That is the order, my lord. Your lordship in para 6, my lord.
There are 6, yes.
It is be stated that the decision consent order, the authority and basis of the inquiry report fairly considered that the earlier selection and appointment on the basis of such selection as well illegal and arbitrary and such both the parties are agreed for fresh advertisement and selection and indicating above, above civil law number 2340, there was a private respondent, but none appeared before him. If a selection list suffered from gross irregularities and illegalities committed by the selection board, the same cannot be acted upon, and no right to appoint flows from the such selection list, and any appointment made from such selection list also issue factor must fall through in as much a person cannot be allowed to make wrongful gain out of illegal state of things. If any authority is required for this proposition of law, one may have look at so and so. So that is the order, my lord. Against that, my lord, they file a writ appeal, my lord. Page 56, my lord. Page 56, my lord.
Yes.
In the writ appeal, my lord, your lordship straightway goes to page 63, my lord. In page 60 is the last portion, my lord. We do not find that the order passed by the learned single judge called for any interference by us. We would, however, like to make a slight modification of the order to extend that in case the appellant submit their reply to the so-called notice, the authority concerned shall consider their reply without being prejudiced by the observation made by the learned single judge objection. So that was also upheld, my lord. But in spite of that, my lord, what they are doing, my lord, those persons who, my lord, came before this honorable court, challenging the selection list, my lord, they were appointed. Just because they came before this honorable court. Your lordship kindly page 67, my lord. Page 67. Page 67. In pursuance to the order passed by the Honorable Guwahati High Court on 8/9, writ appeal number so and so, state level so and so, department so and so. Discharged without notice any resigning reason that you are from the following persons are hereby appointed temporarily and until further order extension officer in order to the direct so and so. So there are 8 persons they were appointed, my lord. Those are, my lord, responding in my case. In fact, they file a writ petition to Cylinder, my lord.
These 8 persons were the writ appellants.
my lord.
These 8 persons were writ appellants.
No, they are the writ petitioner. Some of them, I'll
Writ
come to
petitioner
that.
in which case?
There are writ petitioner, my lord, your lordship will petition, I'll indicate that, my lord, there, because there is, that order was passed in several writ petition, my lord. And page 49.
No,
there
but
are-
this order refers to 1811/99 in writ appeal.
Writ appeal, my lord. Pursuant to the, my lord, single man, there is writ appeal preferred against the single man judgment, my lord. That was, my lord, a vote, there are 3-4 writ petitioners there, my lord. In fact, your lordship, my lord, see that there is no direction also in the writ appeal also. But they were appointed, my lord.
No, I'm asking whether these 8 persons were the appellants for the writ appellate court.
No, they are respondent, my lord.
It's not the mind of the petition, they are not the party. They filed the.
No, that is third down. No, that is, I'm not talking.
Yes, it is the first.
No,
That
no.
was 45. As stated that without this, the order passed by the learned single judge. That line has not been.
No, that is third down.
Actually, Lordship, the petitioner came to this honorable court quite later on. There were other petitions which have been disposed of, then those were challenged. He was not before the court till that point of time. He came very late.
Actually, let him finish. Yes.
My lord. So these are the person, my lord, they were appointed, my lord. Then, my lord, your lordship now come to, my lord, page number 84, my lord. That was the judgment, my lord, which I preferred before this honorable court, my lord.
Yes.
So I preferred a petition, my lord. Since I am the selected candidate, my lord, that petition was, your lordship, kindly see page 88, my lord. Because I made some information, my lord, I asking for some information, my lord. How many persons were appointed, my lord, and all. Then, my lord, this petition was disposed of, my lord. Page 88, your lordship, kindly see. This respondent number 2 shall cause an inquiry into the matter and ascertain the correctness of the allegation made in a writ petition, take a appropriate action. The petitioner has paid for the issuance direction inquiring the respondent to disclose the step taken by the to fill up the vacant post of extension officer under Director of Industry and pursuant to the advertisement dated 16/10/2002. Oh, my lord, sorry, I have to forget another thing, my lord. After this judgment, my lord, they have, my lord, because there is a agreed order, my lord, in pursuant to the order passed this honorable court, they have published an advertisement, my lord. They have published the advertisement, my lord. Page 65, my lord. Page 64, my lord. Because in single man's order, my lord, single judge order, my lord, there is a both side agreed, they will go for face advertisement. Accordingly, my lord, in 2002, my lord, there is a face advertisement issue, my lord. Page 64, my lord. But that is not been acted upon till today, my lord.
So, Mr. Mohanto, what is the petitioner seeking in this writ petition? What is the relief?
My lord, petitioner seeking relief, my lord, that from that select list, my lord, person below me were appointed. So I may be allowed, because since they are continuing, I may be allowed to appoint, my lord. My case may be considered, my lord. That was the case, and that's why, my lord, your lordship kindly see, they have taken a stand that we send a proposal to the government. It is consideration. That's why I'm showing the orders of this honorable court, my lord.
But that select list has been set aside by the learned single judge.
But those person, all are working still today.
Sorry?
All are working till today. All are working till today. In my petition, my lord, it was again set aside, my lord. In my petition, my lord, in the 2008, which I have filed, my lord, 2008, my lord. Then there is a writ appeal filed, my lord.
No, Mr. Mahanta, see. Let us concentrate on the,
My lord,
you are a senior counsel,
No, my
so
lord.
we'll go on the legal issues.
my lord.
We'll see if relief can be granted or cannot be granted, we'll see that. But let us first look at the legal issue.
My lord.
There is an order of the learned single judge, which was passed on 1/9/1997,
Right.
saying that the select list is illegal. No appointment whatsoever can be made from the said select list, correct?
My lord.
You are saying appoint me on the basis of said select list. Of course, that order will not be passed. There is no question about it. That relief is not maintainable. The second limb is that if that is the case, why have we appointed those 8 persons? Your case is that that list
Below
is
me.
gone,
That-
but since you appointed these 8 persons, so you also appoint me. That is your case,
My-
correct?
My lord. Since
Now-
they are below me,
Now, there is nothing called negative equality or equity. That is a standard procedure.
my lord.
Why they have appointed the other 8, that they are answerable. That because this is a public law remedy. And if a question is raised, then they are answerable to that. But a writ of mandamus will not lie to appoint your client against the list of 1995.
My lord.
That you are very clear, or
My
you
lord.
have something to
My-
say on that? That you are clear.
My lord.
Okay.
Then, my lord, that's why I'm reading the order passed by this honorable court, because this while issuing rule, in this case in 2017, my lord, they came with a proposal. Other side, because your lordship kindly see here in this case, my lord, from the very beginning, my lord, there are different set of lawyer come, my lord, different proposal given to the court, my lord. That's why case is lingering. Your lordship kindly see in 2017, my lord, they says that we made a proposal. That whether everybody can be accommodated, not, we have taken a decision in this in department, my lord, and as well as in the assembly, they will take a decision, my lord. That is a submission made before this honorable court. And this honorable court asked them to produce the proposal. And you go ahead with the proposal and come with a affidavit. That's why, my lord, that the commissioner was asked to appear before this honorable court. And he appeared. He says that we're going to file an affidavit, but till today that affidavit is not been filed. That is why I'm submitting on that, reading the orders passed by this honorable court, my lord. Now, my lord, they cannot change their stand, my lord, until unless they file this affidavit, my lord. But those illegal appointees are still controlled. Some of them, they come with a, my lord, one miscase that our salary should be released. Salary was released. Some persons were already retired, my lord. Today problem,
These appointments were made in 2021,
my lord.
22 years back.
Yes, my lord. In fact, my lord, their
These
department,
appointments were made in 95 only, before the select list, in fact, like, I'll have to come to, because these appointments, they have been appointed long time back, it's not 21. What is this?
No,
Why 21? They have been
no, I'm
appointed
not saying that 21. Am I saying 21 appointment? I'm not saying it. 21.
No, that's all.
No, I'm submitting, my lord, what I'm pointing out, my lord, there, because giving the undertaking before this, my lord, there.
So, Mr. Manta, this court has got a feel of your case. The problem is with the 8 appointments. Otherwise, there is nothing. Otherwise, there is nothing. in this
Yes,
case.
because they are below me, yes.
Now, these 8 persons appointment was made in which year?
8% appointment were made, my lord. 2001.
That is what I said just now, 2001. According to you, their appointment is on the basis of the select list of 1995,
Yes,
nothing
Yes.
else.
yes.
Mr. Kalita says it is not select list of 1995.
No, the same select list.
My lord.
Same, same, I was talking about, I thought it was 21, it has been stated. It's in 2001 day. I still
So-
correct.
So the
From the
point
same
is,
select list.
how could you have made these appointments on the
No,
basis of?
Lordship, there is a factual matrix, it's quite long, because there were a lot of petitioners here. There several rounds of petitions happened here, Lordship. Several rounds of litigations happened. There were stay orders to that. Then like, because of the stay orders, only some appointees and appointments which have been made already. Those have, they have been working because of the stay orders, nothing else.
No, the select list was set aside by the learned single
Select
judge.
list was set aside, but select list was set aside, then division bench modified that order.
Hmm.
Then so-called notices were asked to be sent. Then a committee was formed, so-called notices were sent, then those have been reviewed. Then some termination notices have been sent, then those termination notices have been challenged. Then there were several inquiries, there was chief secretary inquiries also there. Then there is specific.
No, Mr. Kalita, you
Look.
see, the learned single judges found that the selection committee conducted the process with irregularity,
Correct,
having a vitiating effect on the select list.
correct,
Right?
correct.
So therefore, it was set aside and a fresh advertisement was directed to be
Correct,
issued.
correct.
In the writ appellate court, the division bench does not disturb the order, but adds a line that show cause notices are
Has
to
to
be
be
issued.
correct.
Now, since it is a question of validity of the select list, the stand of the department could be either that it is illegal or the entire list is legal. It can't be in between.
Hmm.
It can't be that for some candidates, the select list is legal, for some candidates is illegal. That can't be done.
Hmm.
So therefore, if it is a fact that these 8 people have been appointed from the list which was set aside by the court, and the department has been evasive, the relief that we propose to give him is not to appoint him, but give him the salary of the same period which has been drawn by one of these candidates to be recovered from the salary of the officers. You may make your arguments on that. There is nothing more to hear in this case.
No, Lordship, before your Lordship goes to that,
Some compensation, obviously.
this Lordship, I would like to submit a note here, Lordship, like what has happened prior to this, because he has come to the court pretty late. So I have a issue of, I'll have to raise an issue of delay and laches also. Because he came to the court after 15 years. Selection list was.
Anything else you have to submit, Mr. Mahanta? You don't have otherwise a case. Only thing is,
My lord,
yes,
no, my
there is
lord,
nothing else in this matter.
in the midst of the argument in the earlier occasion, my lord, what they have submitted that because they were asked to, no,
Mr.
they were.
Mahanta, these are all, you see, ancillary issues. The main issue here is, can your client get a direction from this court to be appointed? The answer is no, because law does not permit it.
My lord,
If you want to convince the court that the law permits it, you are free to argue. But perhaps it will be a wasted
My lord.
effort. A writ of mandamus can be issued only to enforce a right of a candidate. So you are saying something which means 2 wrongs cannot
cannot
make
get
a
right.
right.
Yes, that I
So
understand.
if
that I
those
agree.
appointments are wrong, that doesn't mean the court will pass an order which is also wrong. That cannot be done. So only question now is, does your client sustain a claim of some form of compensation on an injury being caused to him?
No.
That will depend on
No,
what answer
why I
they
am
will give.
submitting, my lord, this argument, same argument in the earlier occasion also, then they came with it, yes, no, we don't go to merit, we'll, my lord, consider his case, we place it in the parliament assembly, so we take a proposal, he shown some letter also before this honorable
How
court.
old is the petitioner now?
My lord, he's already 54, my lord.
He cannot be appointed for that reason also.
No,
You
why,
missed the bus.
no, if, on the basis of that is, they have shown
No,
this letter to
Lordship,
this
what
honorable
has
court.
happened, Lordship, I'll just explain what my learned senior is saying, but I'll just explain.
But why don't you allow him to argue?
Yeah, I'm sorry, Lordship,
Yes.
I'm sorry.
No, if, then your
No,
lordship,
he's-
that your lordship kindly, for my satisfaction, your lordship kindly see the order. If, my lord, what I have submitted.
So
on the
I
record.
am posing questions because we are interacting in
My
an
lord,
intense
okay.
manner,
No,
so that you get a chance to respond,
exactly, my lord.
not because court has formed an opinion.
My lord, actually, what happened, same type of my lord argument was going on, then he says, came before the judge, yes, we have considered his case, so we'll place it, they have taken the decision, that's why I am showing the orders, my lord.
You show, but none of this is going to help your client. He cannot be appointed today. That's the end of the matter. Even if they come and say that we are doing it, we will
No,
stop it.
that's why, my lord, your lordship in 2018, my lord, because of that, it was adjudicated in 2018, my lord. Because of their, my lord, proposal, my lord, court is, my lord, go slow and yes, you do something, place before the court. But they have nothing doing, my lord, no affidavit has been also filed, my lord. Because he has given an undertaking, my lord, we're going to file. No, why I am submitting, my lord?
What is the order you are seeking here, Mr.?
My lord, my submission before your lordship,
Hmm.
those persons who are below me, my lord, they were appointed. Why they were appointed? Just because they oppose this honorable court. If they are, my lord, below me and they are allowed to continue, why they have not taken decision about me, my lord? So otherwise, my lord, your lordship kindly see that illegal appointed are continuing, my lord.
And this matter has been pending since these appointments happened in 2001, right?
My lord,
And this writ petition was filed in 2010.
2010. No, my lord, there are series of litigation, my lord. I'll place before your lordship, because today, my lord, who is assisting me, my lord, because I am coming in this case, my lord. He is not here, my lord, my assisting counsel. But even then, my lord, arguing with the whole case, I am not going to take because he mentioned his case, my lord. If your lordship require, I'll give him all serially, my lord. I'll make a note, my lord, because this is not the, again, my lord, in my writ petition was allowed. Then, my lord, against my writ petition, my lord, they came before the division bench, my lord. And division bench remand this, my lord. Because,
So then you place your case, whatever is there, you place it.
my lord, your lordship,
Do you want some time accommodation?
my lord, I'll make a complaint, my lord. Yes, I'll do it.
Mine happened at fact, my lord, because mine is completely separate. Tag went this matter, my lord, and otherwise I could not get any chance to argue the matter. Actually, what facts have been my learned has been submitted, my lord. Submitted.
Your matter is item number?
Item 43 and 44, my lord.
All right, we'll hear your case. This is item 42.
42, my lord, my private respondent, they are appearing on behalf of the private respondent, also somebody appearing, my lord. So they file a affidavit. They file a affidavit, and that case, my lord, yes. What my learned friend says, my lord, that is earlier round of litigation, and my writ appeal, my lord, I am not yet to be placed, my lord. I have all, my lord, not with me now, my lord. Give me 1 day time, I'll make a profile, give it to your lordship, my lord.
All right. You are appearing for whom?
Well, 16 and 19, my lord.
How you have been appointed, on what basis?
My lord, actually, Mr. Amnat will appear in this case, my lord. I'm not in the record, my lord. That's why. The next time, my lord.
We are hearing a matter. Who will appear, who will not appear? We are not asking for those details.
Yes, my lord.
Who has gone where, what problem, person, we are not interested in all this. When a case is being argued, you have to place your matter. Yes, you are appearing for the private respondent.
Yes, my lord.
Which is the select list based on which you have been appointed?
My lord, actually, that is the problem. Mr. Amnath, my lord, he is preparing, my lord. He has got personal difficulties today. Let him complete his part today, my lord. So we will make our submission.
So,
But-
Mr. Kalita, we'll have it on Tuesday. But name the figure and who are the officers who are to pay the money. If their appointment is not based on any proper selection, that is, then it is illegal.
Whatever is there on the record, I
It
cannot.
is illegal. So you have to give me the name of the officers. We'll,
We have appointed.
they all, including all who are here, proportionately, they'll have to be here.
All retired.
They'll have to do
No,
it.
I'll show you.
It can't be like this.
Yeah,
A High Court sets it as an order and you make appointments from there. These are government officials. They can't behave like illiterates. Because there is a stay order, they will make appointments.
that part also.
Some transaction has happened somewhere, it is very clear. So now
Then Lordship,
it is payback time.
whole select list appointment was illegal, Lordship. Chief Secretary has come to a conclusion saying that the whole thing is incorrect. But the only thing is the Lordship stay orders were there. The people are working since 1993. So that's why, Lordship, we had some, from the department, there was a proposal came, whether we can accommodate those people, because those people are illegally appointed. That was basically, pending is there from Chief Secretary. There are other IS officers, 3-4 inquiry committees happened. So their proposal was that whether we can accommodate them. And we sought some cabinet approval for that, but that did not happen. That was the thing. Because since these people are working from 1993, a lot of people have already retired and some people have expired also. That's the department's concern. Nothing otherwise, not see these all appointments, not see. There were 3 inquiry committees, not see. One by specifically by the on the direction of this honorable court by the chief secretary. That those things are placed.
All right. So Wednesday at 2 p.m. we are fixing this matter. Next Wednesday. Next Wednesday.
Next.
My lord, my humble submission before your lordship.
Yes, yes, we'll hear you. Why are you? Ah. You have called, not called? Someone? Wednesday at 2 p.m. as fixed parted matter.
My lord.
Item 42.
Yes, my lord.
And Mr. Boda,
Yes, my lord.
this matter will not be adjourned on the
Yes,
next.
my lord. Yes, my lord.
If some counsel is not available, you have to make alternative.
Yes, my
arrangements.
lord.
Unless it has something happens, emergency happens in the morning,
Yes, my lord.
those days are gone. We
Yes, my
can't
lord.
keep waiting.
Yes, my lord.
Courts cannot be asked to wait because
Yes, my lord. I will
counsel is
prepare
gone
it.
somewhere. That
In that
cannot be
case,
done.
in that case, I will prepare, my lord.
That is your client's luck,
Yes, my lord.
but luck is luck. If
Wednesday.
those days are gone, when you can just come and say, my senior has gone there, my senior is gone here. We will,
Yes,
this
my
court will not entertain.
Yes, my lord.
You can do whatever suits you.
Yes, my lord.
Yes. Make alternative arrangement, have
Yeah.
backup counsels. If
Yes, my lord.
counsel number 1 is not available, who
Yes,
has
my
to argue? As simple as that. Yes, you please, can you please stick this.
My
Please
lord,
now call 42 and 43.
my lord, item 80, my lord.
Uh-huh.
Now I am got appointed with them, appointed. As such, I want to do this petition. I got appointed, I am appointed. Appointed.
You keep waiting here in the last item. Why have you come in between?
I presume
You
that.
go and wait there.
My lord. I presume that item is 50.
How can you come in inside when we are hearing another matter?
Sorry, excellent,
You think this is a fish market?
excellent.
Forty-three, 42 and 43.
That's fine.
The 42, right, heard Mr. T.J. Montal and senior counsel appearing to the petitioner. Also heard Mr. A. Kalita, learned SC Industries Department, Assam, and Mr. D.P. Bora, learned counsel appearing to the private respondents. On the request of learned counsel for the writ petitioner, hearing of this matter, further hearing of this matter stands adjourned till 14th of June 2023. List this case again on 14/6/2023 at 2 p.m. as a fixed parted matter.
May I please your lordship, my lord? Your lordship kindly come to the, my lord, writ appeal order, my lord, which has been NS page 45, my lord, 8. Page 45, my lord.
Yes,
Lordship, kindly just paragraph 5, just before. We would, however, like to make a slight modification of the order to the extent that in the case the appellant submit their reply to show cause notice, the authority council shall consider the reply without being prejudiced. That line important, my lord. By the observation made by the learned civil judge affecting their cases. Have you also got it?
yes.
Actually, writ petition, when writ petition was filed, my lord, we are not the party respondent. We are not the party respondent in this case.
Hmm.
Then we file a writ appeal, my lord. We file a writ appeal, we made the case because, my lord, at that time, my lord, there is no record is available, my lord. And my lord, no record is available, nothing is available, my lord. So how can the order has been passed an inquiry report stating ascertain who is the genuine and who is not genuine? Because advertise has been made on the basis of the advertisement, my lord. We are appear in the written test. Subsequently, we are appear in the viva voce test, my lord. Then select list was published, my lord. Then, my lord, records has nowhere found, my lord. Then a writ petition has been filed by the some petitioners, my lord. Writ petitioner who are not selected in the case. Then this inquiry order has been passed. Then we are appearing in writ appeal, my lord, stating that we had been heard, my lord, all these things takes place before the court. Then court has said that without affecting the right of prejudice by the observation made by the court, we shall be heard. Accordingly, my lord, so cause notice was issued, my lord. And on the basis of so cause notice, my lord, we have given reply, my lord. And my lord, a finding has been given, my lord, that your lordship will find, my lord, page 51 Annex I, my lord.
So, Mr. Chaudhary, what is the relief your clients are seeking?
Yes, my client was really speaking that there is an order of the, my lord, Honorable Justice B.K. Sharma. There's all the inquiry which has been made earlier, even in the writ petition also, impounded by the Honorable Court. So court has said, this person are working for 10 years and we could not ascertain from the, because record is not available, we cannot ascertain these things. So with 10 years, so they will be allowed to work in the office, my lord. Because 10 years has been going, and assuming it is an irregular appointment, my lord, they will be allowed to continue. Then they file a writ appeal, my lord. That writ appeal filed by the, my lord, state, my lord, and that was dismissed. Okay, so some private respondent, my lord, that was dismissed. Meaning thereby the single judge order has been stand. In the writ petition, we are not the party. I am showing this because the person who has
Where is the order of the landed single judge? Which page?
yes, my lord. Page, my lord. If you also go to that on page 56.
Yes, let us read this order. Let
Yes,
us-
my lord.
Hmm.
Everything is available. I'm reading the whole order, my lord, because everything is available in that order, my lord.
Hmm.
The writ, have a lordship got a page 56?
Yes.
The writ petitioner directed against the order of dated 16/10/2000 terminating the service of the petitioner as the extension officer under the Directorate of Industry and Commerce. The petitioner were appointed as an extension officer under the Directorate of Individual Appointment order dated 3/5/95, 25/7/95, 30/12/94. Various writ petitions were filed challenging the legality and validity of the selection process in which preceding numbering along with 150 were purportedly selected. By a common judgment on order dated 1995 passed in those writ petitions, the selection and appointment were held to be illegal. However, it is provided that before cancelling the appointment should be given opportunity to be heard. The said sergeant was carried out on appeal by way of writ appeal number so and so, which were disposed of by the Honorable Court. The division was while abolising the judgment order singularly made a modification of the order, providing the case appointed submit reply so cause notice. The concerned authority shall consider same without being prejudiced by the observation made by the Lioness Singular affecting their cases. Pursuant to the said judgment and order, division bench individually identically only so cause notice. All dated 3/1/2000 were issued. No specific count was indicated in the so cause notice except making a fake statement that petitioner were appointed through some irregular procedure without specifying anything as to what were those irregular procedure, as to how the petitioner involved in such irregularity. The so cause identically with that by which petitioner will submit their reply. They also submit their testimonial, academic certificate, call letter, interview appointment letter. The petitioner responded into the said so cause notices by filing their individual reply and submitted their document as he was directed to produce aforesaid so cause notices. This was followed by the impugned order terminating the service of the petitioner in respect of the petitioner 3996/2000. The ground of termination was the failure to qualify written test. In case 7 petitioner involved, the ground of termination service petitioner 1 to 7 petitioner stated there. They are qualifying the well the ground of termination of remanding non-incursion in their name, Because I read that, my lord, order, my lord, that order, screening committee order. In screening committee said my appointment were made in valid terms, my lord. These 4 petitioners. And other cases that they could not submit their either viva voce test or written test. That is why they may be terminated if they are not producing. Although I have submitted additional if I have taken all these things. In addition to the learned senior government advocate, and this petitioner will fail in the examination, my lord. What they have made. obtain instruction whether the service of any other extension officer terminated, the matter was again taken up, which the learned senior produced photocopy of to select list the name of 150 and 152 candidate as per letter dated 532 addressed to him. The deputy commissioner directed or investor, the answer script and mark sheet are not available. That the list containing one candidate treated to be final select list. Our name in that select list, my lord. Since my lord, this is not available in the inquiry. If you also go to the inquiry, that time also not available, my lord. When this single judge order has been passed, my lord. Since the informant sought for a recorded order that 25/2 were finalized, the personal appearance of the said deputy director on 10/3/2004 directed by the order 8/3. When the matter was taken up, the deputy director Hemo Deuri appeared in person before the court on 10/3/2000 on specific query made to him as whether the original select list is available or not. He submitted no such select list is available. He also submitted the answer script. Mark sheet are not available since 1995, whereas writ petition was filed 1996, my lord. At that time also that is not available, my lord. About the validity of purported select list photocopy, same has been treated the final select list in the same or division bench of this court is judgment, the aforesaid order writ appeal. He also submitted the service, none other than petitioner has been terminated. He finally submitted a fresh selection is going held under ensuing election with the petition be considered a likelihood the service regular. I have heard so and so and council. Mr. So and so submitted that individual and identical so-called notices are issued to the petitioner contain fact statement like irregular procedure. There is no specification as to who are those irregularity and to how the petitioner is such irregularity. He submitted the so-called ought to be specified. Indicated purported irregularity and inability person to meet the illegal actively. He submitted issue so-called notice which is a person into the aforesaid judgment. The division may empty formality the respondent that impugn action has been pursuant to the said judgment. The court reluctant to interfere on the same on being pointed out. Other appointees have been disturbed. They have been continuing their service. It is petitioner who alone pick up and newly implemented respondent not made grievance against the petitioner. Mr. Dhar submitted, in fact, the respondent are also aggrieved in the content service. However, the fairly considered private respondent have not initiated independent proceeding against continuation of those service. It is only 11 petitioners said respondent have supported the action official respondent. I have considered the submission advanced by learned counsel have also material record. The impugn order were issued terminating the service of the petitioner on the certain ground and content to selection. The respondent could produce no original record, although same were called, except production of two select lists containing the name 150 and 152 consecutively, respectively. Although the list containing 150 name has been stated to be valid list, no basis for same has been indicated either by affidavit upon the production or record, personal appearance, deputy, as per his own statement made in the court. 10/3/2004, the answer scheme marks are not available since 1995. At the time inquiry, that is also not available, my lord. If that, so I fail to understand what basis impugn order were here issued assigning the reason failure to qualify the written examination, non-appearance name in the final select list. Referring to the division bench judgment 18/99, there is a list containing 150 names. Said submitted, it was a basis photocopy 150. Even this list out of 11 petitions, 7 petitioners find place, it is to be not understood and how the why at least 7 petitioners were terminated. There is no dispute. That is important. Were appointed in the issue individual appointment on the way back 1994-95. We are appointed 94-95, and they have been continuing in their service till date. By now completed almost 10 years of service. Now we are completed 25 years of service. Some person were died, my lord. Their widows got, my lord, pension as per direction of the honorable court, my lord. That order
So
got
petitioners still in service. They are serving.
There are many petitioners, my lord. In this case, all the petitioners in service. In other cases, next case, my lord, there are 2-3 petitioners die. Their widow get, my lord, pension. As per direction of the
So you are serving on the basis of a stay order.
no stay order, my lord. How can my lord stay order?
So
Because
what is the relief you are seeking here?
yes, my lord, I am seeking that enquiry report, my lord. One enquiry report has been submitted, my lord, by the chief secretary, which has been ill-founded by this honorable court by this judgment. And it was filed writ appeal. Writ appeal was also dismissed. That facts could not never produced before the court, my lord. And my lord, because order infounded, now it is could not be ascertained who is genuine, who is not genuine, because 94, 95, my lord, there is no record is available, my lord. And my lord, this 96 order, which has been passed on the inquiry, but that at that time also, my lord, the record is not available, my lord. So this honorable court take this view, my lord, as because they are working 10 years of service, my lord, and their service has been regularized. This person are those person, my lord, who are failed in the examination as per screening committee report. And we, the 4 person has passed, and that our appointment has been made strict in legal sense. Other cases, they have stated they could not produce the either written test or viva based in 2001. That is why if we could not produce, that should be terminated. We have given explanation also to that effect. I filed an additional affidavit, assuming but not admitting the fact. Yeah, I could not given them, my lord, written test, my lord, admit because somewhere I lost, my lord. I have stated. Then, my lord, my appointment will be illegal, my lord. Let them produce the record to show that, my lord, my appointment is illegal, my lord. That is my case, my lord. That is not 11 petitioner selection. It is the petitioner alone who are issued some irregular procedure without, however, activating. It is not the case of the respondent that entire selection has been cancelled. Rather, all the appointment pursuant to the same selection has been continuing in the service. It is only 11 petitioner who were issued so-called notice containing fake statement. The petitioner will duly replied the same along with the supporting document. Thereafter, the impugn order were issued. Continuing reason which necessarily could only be basis record. However, as per their own admission, the respondent are not possession in any record, including answer sheet, result sheet, and the original sheet since 1995. If that is so, it is not understood as what basis termination order of termination of all 6/10/2000 could be issued, terminating service the petitioner. It will be dangerous or unwise rely on the photocopy of the purported select list which respondent relies as to the way not select even as the content of 7 petition notice above. There is another aspect of the matter. The respondent sought to give an impression to the issuance of so-called notice, the impugn order of termination, affidavit on the service, petitioner were not terminated on the basis of said judgment of this court. The division bench of in its judgment early indicated that before terminating the incumbent, they should be given an opportunity to have say in the matter. It was indicated the authority would not be guided by any observation made by the learned single judge, validity of the select list, the necessary required to be responsible, carry on meaningful exercise, so giving an opportunity of being heard. And for that reason, those appointees at all appointment were in doubt. However, as noticed, the petitioner were vague so-called notice followed by impugn order of termination. That above, coupled with the assertion by the writ petition that their service were terminated with a view to accommodate 11 persons who were not selected in the statement, who has been denied the affidavit, denied and clarified the led to irresistible conclusion that impugn action on the part of the respondent was not bona fide to exercise power. Law is settled that when a point which is ostensibly point of law is required to substantiate by fact, the party raising the just pleaded prove the fact, evidence which must appear from the writ petition if he is respondent from the counter affidavit. In the instant case, implicit statement made even by it was only view accommodate the person's services were sought to be terminated. The test of bias is whether a reasonable man fully appraise all circumstances would mean serious apprehension of bias. The test is whether a bias affected decision. In this sense, it is often justice must not be done, but must also appear to be done. The respondent ought to be fair, impartial, objective, their decision-making process. Unfortunately, it is not discernible in the instant case. Even otherwise, the petitioner were by now rendered almost 10 years of service. Fact that respondents are not opposed the regularization of service. Our service has been regularized. We are get gradation list also. Our names on in there. through another process of applying principle of equality more in the given of the circumstances of the case, petition protected. In more, I am consider opinion that there by way of issuing of so-called notice ill-founded and not based on record. Whole is ill-founded, my lord. Once the basis proceeding is granted, action taken same will follow the flow of general principle applicable consequent order. The impugn order are not sustainable. Was consequently petitioner shall be entitled. The serviceman as may be admissible and the relevant service rule continuity service for the dead. To that against that order, appeal has been filed, my lord. This is the order, my lord. By some, my lord,
So, Mr.
respondent.
Kalita, what has happened to this inquiry report on 18/5/2013? What action has been taken?
18/5/2013.
One thing is that these persons who are failed in the examiner, that was not considered in the inquiry report stating that they are because there is an order passed by this honorable court. That is why we are not considering whether they are failed in the examination as per screening committee, and we pass in the examination, my lord. And my lord, that was a screening committee report said, that I will read, my lord, that our appointment will make strict legal sense. And now I am going to the writ appeal order, my lord, passed by this honorable court, my lord. Only one copy, my lord, let's read that order. What bola tha ase? Yes, man, I got copy. Para 12 and 13 important. Para 12 and 13 of writ appeal.
So, Mr. Chaudhary, why the division bench has made it clear that your service cannot be disturbed?
Yes,
Then why have you come with
no,
this?
my lord. Actually, this is not the, I am not that person, my lord. The person, you will also kindly come to the annexer, I page 15, I will be clear everything, man. Last just 1 minute, my lord. Actually, this order also followed for me also, my lord.
Yes, find out this order from our CIS. It is not complete. Half the things are not readable.
Annexer, I page 51.
So it is a covered case under the earlier
Yes, my
judgment.
lord.
No, not, actually, Lordship, that's one subcommittee was formed. So after a division bench's judgment, a committee was formed to issue the show cause notices and to find out, and they have been given opportunity to produce whatever records they have. Because Lordship has found out there is no record with the department. That has been admitted fact. Only 2 select lists were there, and there's to get to photostat copies, no copies, and no records were there. So they have been asked that, like, you produce the admit card and like your date of coming to the privacy test and all these things. Some documents have been all for by the department. And committee sat down with those documents, whatever were available. Some people could produce certain documents, some people could not produce certain documents. And the committee made a report on the basis of that. That like these persons have, like certain persons have complied with the direction given by the subcommittee, and some people could not. So on the basis of that, like they decided that certain termination notices will be issued. And against that apprehension of that, the termination notices will be issued. Certain people came to the High Court again. Then that committee's report was stayed. That
So there was no termination.
no
notice-
termination could be effected.
No, these petitioners, they were not even served with a notice,
They have been served. They have been served with a notice, so cause notice.
but their services were not terminated.
Not terminated. They have been still working, Lordship. They have been still working. But in the Tilaknath's case, Lordship, Tilaknath basically, the other case, Lordship, Mr. Mahanta has argued. In that case, he sought for an inquiry. So in that case, there was an order that Chief Secretary should do a detailed inquiry. And he has done a detailed inquiry. And he also came with the findings, certain findings.
So their apprehension that if this inquiry report is now acted upon,
Yes, my lord.
then it may
That is their
prejudice.
apprehension.
That is their
That
case.
is their-
That is-
But 10 years before this inquiry report was given, department has not taken any action on
The
that.
department wanted to take action, but there were stay orders, Lordship. When they have filed a petition, other people were there, they came to the court. So those came, termination notices were stayed. So stay orders were there. On the basis of that stay orders, there was a lot of people are working.
So now
Now-
also there are stay orders operating.
Lordship, yes, those stay orders. are-
In which cases?
My
There-
case.
In his case also stay
My case.
orders are operating.
Both
In his
in my
case also, in both his cases, stay orders are still operating.
We are receiving the inquiry report. As of when I received the inquiry report, my lord, we approached before this honorable court on the ground that this inquiry is ill-founded for 8 or 9 ground, my lord. May my lord said all this ground, my lord. It was down behind the back of the petitioner, first. Secondly, the inquiry document which has been considered in the inquiry is ill-founded by this honorable court, my lord, in BK Sharma judgment, because no record is available. 13 years, my lord, the inquiry never called in that expert inquiry was done against the petitioners, my lord. Fourth, my lord, Chief Secretary did not consult to the department. At that time, the council is different. They stated that we are not consulting the department on my lord before made by the department. Annexer 51. With reference, I'm not reading point number 1. Which say that details of the case based on submitted report. Again, backdrop of the Honorable High Court order yet to be implemented with a view to avoid contempt is considering the following decision, government will furnish necessary action. 1, time for 15 days may be given. 19 number of extension officer for submission of document. If they fail to same within the limit, their services terminated. This is my second case, my lord, where either or vivacy test or written test document could not be produced. We give the explanation. That is the order, my lord. We give the explanation. Second, this case. 52 number extension officer who are found in order in all respect may be allowed to continue. This is my writ petition. This is petition, my lord. Then, my lord, as regards to so and so, this is not important. Point number 4, the extension officer whose name did not appear in the select list but were appointed illegally should be terminated forthwith. 7 number extension officer who were unsuccessful in written test but appointed illegally be terminated for it. This person, my lord, and this 6 person, all 4, 5, 6 has filed this writ petition, which I read, my lord. And accordingly, writ appeal got finality, stating that they are working 10 years, 15 years in the service. No record is available. So it could not be ascertained who is genuine, who is not. Because their appointment were in 94, 95, my lord. The record were not available since 1995. And the meaning there were 96 inquiry report which has been produced before the court without basis of any record, my lord. That is why writ appeal order has said, without prejudice to the order of this honorable court, my lord, that this inquiry should be made, my lord. Then your lordship come to the, my lord, inquiry report, my lord. Basically, this inquiry was done within the period of 20 days. Without consulting the petitioner, my lord, subject to correction of my learned friend at that time who has appeared, it was not considered to the department. Some photocopy of the document has been taken. And in that inquiry report, my lord, that writ petitioners who are writ petitioner in my lord, earlier round, my lord, 2975, they are not touched because their order has got the finality. They are working for 10 and 15 years. Now, my lord, I am, my lord, challenging this order, my lord, only this inquiry report submitted by the chief secretary, because, my lord, in their affidavit, they have categorically admitted it was filed on 20 days. And, my lord, no, it was done behind the back of the petitioner. Document rely on was, my lord, never supplied to the petitioner. In fact, that document is not available in the office, my lord. And some photocopy has been produced before the, my lord, officers, my lord. Because that has been admitted by my lord, earlier council also, my lord. As subject to correction, whether any original document record is available, my lord. And, my lord, it was not done on proper facts, my lord. Because those persons who were failing the examination not touched by the inquiry. Chief Secretary did not consult the department. It is up to my learned friend. Inquiry based on previous inquiry which were found be ill-founded by the honorable court. In writ petition, my lord, the inquiry which has been ill-founded by this honorable, that was basis of this inquiry, my lord, of the chief secretary, my lord. My lord, because, my lord, scheming committee report 52 incumbent were given clean sheet, allowed to continue. We are the writ petitioner. He said that these 4 petitioners not in strict legal sense. What has been used in the inquiry report? Strict legal sense. Next, my lord, documents sought and view taken does not match, my lord. My lord, the document which some have been produced, we asked, my lord. Suppose assuming, my lord, for second case, we could not produce them, my lord. Hababasi choices admit card, which was happened in 94, my lord, after 6 years. Suppose I lost my metric admit card. Does it mean, my lord, I am not past metric, my lord? This is not the law of the land, my lord. It is their record. They should show. I will say the explanation also, my lord. Because they are the custodian of the record, my lord. Inquiry done, expertise file is necessary. The view taken by chief secretary inquiry is vague and not specific, my lord. Only vague, my lord. May I read the inquiry report, my lord? It is a long inquiry report, my lord. Yes, no? Oh, yes.
So Mr. Kalita, what does the department propose to do after 10 years? What are you going to make of this inquiry report? You
Your
did not
Lordship-
file any stay vacating application,
Stay vacating, we haven't filed,
then-
we have filed affidavits in all the cases.
right?
Basically, Lordship, department, initial department stand was that stand by the chief secretary's report.
Hmm.
But later on, Lordship, like when, I mean, like I got into this board. Then Lordship, there was some kind of proposition came from the department that since these people are working for so many years, whether they could be accommodated. And then secretary of this department was quite active in this. He took this thing very seriously. And he took it up also for a like cabinet
So
approval.
if you,
But
if
that did
you-
not happen.
if you take instruction and appraise this code that due to lapse of long 10 years of time, the department is not.
That
proposed-
Lordship, that exercise was done. In fact, Lordship, I also took a lot of initiative, but like cabinet approval did not happen because
No, if you don't act on this, we'll close this matter. What is there in it?
Lordship,
If you decide not to act on the report of the chief secretary, then there is nothing in this resolution.
that is correct, Lordship. I mean, then Lordship, I'll have to take I'll have to take a fresh instruction on that. Because earlier, like earlier written instruction was given that was on the file saying that like they stand by the chief secretary's report.
Hmm.
And later on the position.
No,
came-
report may or may not be correct.
Correct.
But this report, you have to take a decision what you want to do after 10 years. Stay order is not the end of the world. You never showed any urgency. You didn't ask the stay order to be modified.
That's correct, Lordship.
Then-
That was not there.
What can you do after 10 years? And in any case, this report cannot be used to straight away terminate anyone. You have to issue fresh
Yes,
offers,
yes,
fresh inquiry,
Yes, yes.
and these people have spent more than 20 years in service.
Yes, they have spent more than 20-25 years, Lordship. That's correct.
And somewhere expired, their
Some-
wife get pension money. Somewhere on the hours of retirement money.
Heard Mr. NNB Chaudhary, Learned Counsel appearing for the petitioners in both these cases. Also heard Mr. A. Kalita, Learned Standing Counsel, Industry and Commerce Department, Assam, who prays for time till 14th of June 2023 to seek instruction as to whether the department is proposing to take any action pursuant to the inquiry report dated 18/5/2013 at this point of time by ignoring the lapse of more than 10 years since the report was submitted. First up, the aforesaid question assumes great significance in view of the fact that out of the petitioners in both these writ petitions, some of them have completed more than 20 years of continuous service in their present office, a few have
20
expired.
5 years.
Nearly 25 years of continuous service, a few have expired. And a few others have already retired from service. Full stop. On the request of Mr. Kalita, this matters are directed to be listed as fixed partnered matters on 14/6/2023 at 2 p.m. so as to enable him to obtain written instruction. You have to take hard decisions, Mr. Kalita. You can't just leave it.
So that was the most difficult part in this case.
No,
Lordship.
but
That's
that
what I
is
have
the job
thought
of the government to take decisions.
Yes.
We'll see whether the decision is in consonance with law. If you want to leave the Pandora box open now, there will be a problem. We have to deliver judgment, we'll go legally. But if you take a stand, we can accept it, keep it on record and close the matter.
Well, I prepared written
This
argument.
is You keep it next. This is the prerogative of the government. Nobody is before the court saying that take action on the report. Report is submitted. Whether the report should be acted upon or not is the prerogative of the government. So if there are good grounds, then either decision may find the approval of the court,
No, actually, Lordship, this, they wanted to give effect to the,
but that is gone.
but that,
Wanted though is gone.
because of some stay orders and all, because.
Right now, what is your stand? What do you want to do now? You want to issue show cause notice to people who are dead, who have retired? You can't. You cannot.
I will take a fresh instruction, though, I mean, like,
If you cannot do that, on what basis will you proceed against people who have spent more than 25 years in service?
Lordship.
Let us come up because if the stand is in a particular way, then we will have to deliver a judgment where many things will again be highlighted. Up to you.
Lordship, I'll take it.
Item 43, 44, 45.
Yes.
Whatever I am appealing.
Yeah, same, similar matter.
Almost similar lordship, only I am not the part of the select list. We were appointed on ad hoc basis in the year 2020, 2001.
All right. You made,
We are also affected by this report.
The report also covers them, so.
all right. The question is what action is proposed under the report? And you have to show me judgments. If they say that we will act on the report,
Yes, ma'am.
then show us judgments that after 10 years,
Yes, madam.
I took the
judgment also. Lordship.
14th, yes.
My lord, this matter pertains to selection and appointment for the post of constable in the Central Armed Police Forces. Lordship, whoever,
Yes. Just wait for a minute. But this is of 2017.
Lordship.
Now it's difficult
My
after
lord,
5
Lordship, that
years.
issue is still pending before the apex court, Lordship. Similarly, situated person have approached this honorable court. This honorable court has allowed the repetitions. Thereafter, respondent Lordship is carried to the appeal. Appeal was dismissed. Thereafter, they have again preferred under SLP, Lordship. And SLP is not decided.
Lordship,
Till yet,
this
Lordship.
matter not similar because in that case, the petitioners were selected, but they were not appointed. In this case, Lordship, he has opted for Assam Rifles. And his marks is only 41 when in ST general category candidate, ST general area candidate, Lordship. And the cutoff mark in that category is 58. Therefore, he was not selected and appointed, selected.
And Lordship, that issue has also been discussed in the repetition, Lordship. And that, my lord, that case is petitioner, Lordship, he offered it candidature. And in the staff.
Mr. Bezbura, after 5 years, these directions cannot be issued in these matters. You have to understand it. You don't agree, that doesn't matter, but understand it.
Lordship, that
If you understand, the court's work gets streamlined. Don't agree, there's no need to agree. We don't pass orders on agreement of council,
Lordship,
but you have to understand, these
Lordship,
are appointments in special forces. We cannot issue directions because 5 years has gone, many things have changed.
Lordship.
And it is 2012 recruitment process.
And that,
And they had prayed for
Your
Lordship,
client had applied 11 years back.
yes.
How can he be appointed today?
Lordship, that advertisement was on 2011
Hmm.
and the proceeding was concluded on 2013. In the meantime, Lordship, similarly situated person have approached this honorable court. Repetition was in our favor. Thereafter, respondent preferred an appeal. Appeal was dismissed on 2016. And again, that issue come to the SLP, Lordship, that SLP is still pending before the still yet, Lordship. on
This is
2000,
Which is the order, similar order, let us see.
lordship, that it is reflected from start from page 48. Start from the page 48. And our issue is reflected, lordship, page 59, paragraph 39. Paragraph 39, lordship.
So in that earlier writ petition 5520, you are also a party.
No, lordship, I am not in
That
party.
is somebody else's case.
It's about
lordship.
here.
But that-
And case is also different, lordship. In
And
that,
what is your stand here?
lordship, he have secured only 41 marks and opted for only Assam Rifles. And the last selected candidates got 58 marks. Therefore,
No, but he is from ST category.
yeah, ST category candidate got lordship 58 marks. General area ST category candidate,
Have you stated in the affidavit?
lordship.
Where is it?
Now I prepared at page 6, lordship,
Serial number 3.
Roman 3,
Para?
Roman 3, lordship.
No, but this is unreserved vacancy. He is a reserve category candidate.
Yes, lordship, against, yes, lordship, since he had exercised his option only for Assam Rifles and the marks obtained by the last selected ST candidates from Assam in Assam Rifles being 58, which is higher than the marks obtained by the petitioner. Last line, lordship. His name was not included in the subsequent select list.
That is correct. Your client had only opted for Assam
Yes,
rifle.
lordship.
Assam Rifle, but not lordship, that judgment says they can consider me also in other paramilitary corps also.
If he has opted for Assam rifle, then why should they consider you for?
Lordship, that our High Court says
Have
lordship,
you filed any rejoinder?
lordship rejoinder has not filed. Take it up on the next Tuesday, lordship, that I will take the outcome of an SLP, lordship, but it says.
No, you get relief if facts, these are on facts, you see. Heard Mr. H. Bezbura, learned counsel appearing for the writ petitioner. Also heard Ms. R. Devi, learned CBC appearing for the respondents. Full stop. The Staff Selection Commission had issued an advertisement notice dated 30/12/2011 for filling up a number of posts of constable bracket GD bracket close in the Central Armed Police Forces. Full stop. In response to the said advertisement notice, the petitioner had also submitted his application opting for
Assam
appointment in the Assam Rifles. Full stop. As per the case projected by the petitioner, he had qualified in all the mandatory tests conducted by the respondents and thereafter was asked to appear before the medical board. Full stop. However, in the medical board, he was declared unfit. Full stop. The petitioner preferred an appeal against the decision of the medical board, which was answered on 11/6/2013 by declaring him as medically fit. Is it?
Lordship.
Lordship. However, in the meantime, the final merit list was published on 17/10/2012. According to the writ petitioner, he belongs to the ST category candidates and had scored 41 marks in the written test. Notwithstanding the same, and despite the fact that the candidate who had scored 40 marks from the ST category was appointed, the case of the petitioner was not considered for appointment. Hence this writ petition. Full stop. Mr. Bezburua has relied upon the judgment and order dated 04/01/2016 passed by the learned single judge in WPC number 5520/2012, allowing the writ petition submitted by as many as 26 candidates. Disposing of the writ petition with a direction to consider the case of the affected persons based on their merit ranking. Full stop. Mr. Bezburua has also prayed for a similar order in the present case. Full stop. Next, by referring to the counter affidavit filed by the respondent number
SSC.
two,
Lordship.
that is the
SSC.
SSC
Lordship.
bracket any bracket close. Guwahati. Ms. Devi submits that the last reserve category candidate who was appointed in the Assam Rifles had scored 58 marks. That is more than the marks scored by the petitioner. Full stop. Since the writ petitioner had opted only for Assam Rifles, hence his case was not considered for appointment.
Lordship, his case was considered for, after he was not considered Assam Rifles, thereafter he was considered for BSF, ITBP and Lordship CRPF. In this case also, he was not qualified.
Thereafter, 58/41, thereafter, she submits that the petitioner's case was also considered for appointment in ITBP,
BSF, ITBP,
BSF,
and
ITBP,
CRPF.
and CRPF. But since all the candidates who were appointed in those forces had
Cut off
scored
marks.
higher marks than
Yes,
the
sir.
petitioner, he could not be appointed. That's first up. Contending that the judgment in order dated 4/1/2016 was passed in the facts of that case. The learned CBC submits that the decision in the rendered in the case, in that case would have no relevance in the facts of the present case. Full stop. I find that the stand of the SSC insofar as the claim of the petitioner of having scored higher marks than the last selected candidate has been countered by the respondents, countered by the respondent number 2 in its affidavit by making the following statement in para 5 bracket Roman 3 capital 3. You have to quote this, which is extracted here in below. Full stop. The aforesaid statement of the respondent number 2 made on affidavit has not been denied or disputed by the petitioner by filing rejoinder. As such, the stand of the respondent number 2 would have to be treated as correct on facts. Full stop. If that be so, regardless of the opinion of the medical board, the petitioner would not have been appointed in any of the forces, including Assam Rifles, ITBP, BSF, and CRPF. Full stop. Situated thus, I do not find any justifiable ground for this court to interfere in the matter. Moreover, the selection process having been initiated way back in the year 2011, the question of issuing a writ of mandamus directing the respondents to appoint the petitioner at this distant point of time would not be in public interest. Full stop. For the reasons stated here and above, this writ petition is held to be devoid of any merit and is hereby dismissed. Yes.
Alright.
Yes.
May it please your worship. Lord, I'm extremely sorry. In the first half, Lord, I just failed to appear when the matter was called up. Lord, this matter, your lordships, on the last occasion, your lordships heard the matter to some extent. And your lordships wanted me to clarify one aspect of the matter, whether it is purely a case of promotion or promotion by way of selection. Lord, if your lordships kindly come to the rule, I have annexed the rule.
Yes.
Page 20, we are concerned with rule 8.3. The petitioner, he is basically the facts are, Lord. Petitioner, he is a grade 4 employee. And he earlier approached this honorable court praying for a direction for consideration of his case for promotion by way of selection to grade 3 post, that is lower divisional assistant stroke junior administrative assistant. This honorable court issued direction for consideration of his case. Respondents considered the case of, there were 9 petitioners, 8 petitioners' case was considered and they were given promotion. The petitioner's case was rejected, saying that he doesn't belong to the secretarial administration department. On that count, it was rejected. A person junior to me, he approached this honorable court by filing a writ petition, praying for consideration of his case. His case was considered pursuant to direction of this honorable court, and he was given promotion. Now the situation is that a person junior to me has been given promotion. I am still to get the promotion, my lord. That is the, my lord, briefly the factual background. I'll just take your lordships the rule involved herein. Page 20 is the rule 8.3 we are concerned with, my lord. May I read, my lord? By selection, my lord, rule 8, page 19, your lordship will find lower division assistant. Appointment to the post of lower division assistant shall be made, number 1, page 19, my lord.
by direct recruitment on the basis of competitive examination and interview as per Schedule 2. Now, I am concerned with Rule 8.3, my lord.
Yes.
By selection from amongst the grade 4 staff and record suppliers of secretariat who have passed the matriculation examination or high school leaving certificate examination or the higher secondary or equivalent examination and have rendered at least 7 years of continuous service in secretariat on the first day of the year in which selection on the first day of the year of which selection is made. Now, there is a note below. Sub-rule 2 and 3 of Rule 8 was substituted by notification dated so-and-so, and the words on the basis of qualifying written examination to be conducted by the recruitment committee as inserted by the above notification in sub-rule 2 and 3 of the Rule 8 were deleted by notification dated so-and-so. So the element of, my lord, written examination was deleted. Then, my lord, will kindly come to second note. The proportion of vacancies to be filled in any year according to sub-rule 1, 2, 3 above shall be 60%, 30%, 60 is to 30 is to 10 respectively. This means that the recruitment of lower division assistant will be 60% by direct recruitment, 30% by promotion from eligible typist by selection, and 10% by selection from among grade 4 staff and record suppliers. In the event of sufficient qualified or suitable people not belonging available in category 3, the balance would be made up from category 2, that is by promotion from eligible typists by selection. Here vacancies include both permanent and temporary vacancy, and typist means both selection grade and ordinary grade typist. So, my lord, the post are to be filled up in the ratio of 60, 30, 10, 60% direct recruitment, 30% by typists, and 10% by grade 4 staff and record suppliers. In the event of non-availability of grade 4 staff and record suppliers, the post is to be filled up by typist and senior grade typist. Now, my lord, will kindly come to page 21.
Just 1 minute, Mr. Das, please take your seat for a minute.
Lord, sir.
So the problem is degree holder. But why did you not promote him earlier? Why he was not promoted earlier?
No, so far as this petition is concerned, Lordship, he has only prayer. Please relax this 2012 notification in my case, Lordship. That is his only prayer, Lordship.
To consider his application, let him submit it.
No.
What is the problem? One promotion in a entire tenure that is now recognized. Where is the judgment? You got the judgment, at least one promotion.
Sorry, Milord.
You got the judgment, one promotion in a career span is mandatory.
Milord, that,
Are you aware of that judgment?
yes, I am aware, Milord. I have got different judgment, but that particular judgment I don't have, Milord. I'll place, Milord. I can place. I can place that judgment, Milord, because you cannot create stagnation. Right of consideration is a fundamental right.
Consider his case for relaxation. What is the problem?
In fact,
For that also, he will first have to establish that he belongs to the Secretariat Establishment Service, Lordship.
So according to you, he belongs to which?
But I'm placing just one notification. This notification clearly says. Lordship, this is Assam Secretariat Grade 4 and Record Supplier Service Rules, Lordship. Lordship may kindly come to one. Appointing authority means the Deputy Secretary to the Government of Assam in the Secretariat Administration Department. And 2, Assam Secretariat means all departments of the Government of Secretariat, including Chief Minister's Secretariat, but excluding the PWD Secretariat. Lordship, this is a rule applicable for the Grade 4 staff of the Assam Secretariat. Now, his appointment was made by somebody in the Water Resources Department, Lordship. So prima facie, as a Grade 4 employee, he is not a part of this particular rule, Lordship.
So he is part of which rule?
Water Resource Department, Lordship.
Where is the Water Resources Council?
Senior, VD Goswami is-
Where is he? Mr. Goswami was there in the
in
morning.
the morning he was here.
Must have gone home today. Is it?
VD Goswami.
Goswami, that's awesome. BD Goswami, Shivati Goswami.
And he is working in the SAD.
Not SAD, it's still under Water Resource Department.
No,
also.
no.
In the campus may be same, Lordship, but under Water Resource.
What my learned friend is submitting, Milord, factually incorrect, Milord. I can show your lordships, Milord. This rule that has been placed before your lordships, I brought this rule by way of an additional affidavit, Milord. This rule, Milord, if your lordships, I'll just clarify this aspect first, Milord. If your lordships kindly take up my additional affidavit, man. Para 3, running page 72. I clarified this aspect of the matter.
Running page 70.
72, my lord. Basically, SAD department disowned me, my lord. So, if I may read, my lord, that the deponent begs to state that as per rule, sub-rule 2 of Assam Grade 4 and Record Supplier Service Rule 1963, Assam Secretariat means all departments of the Secretariat, including Chief Secretary, Chief Minister's Secretariat, but excluding PWD Secretariat. And the appointing authority as defined in the rule is the Deputy Secretary of the Government of Assam, D10 Secretariat Administrative Department, now GAD Department. Since the earlier PWD Secretariat was situated in a different campus outside the Dispur Secretariat, therefore there was no bar for Public Works Department in making appointment, promotion, etc.
No, Mr. Das, these arguments will not impress the court at all.
No, Lordship will kindly
What will only matter is you have to connect his order of appointment with the rules. Campus, something is.
No. Lordship will kindly come down, my lord. There's only one part of it, my lord. The Public Works Department was later on divided into another 3 works department, namely Public Works Department, Irrigation Department, and Water Resource Department. The PWD Secretariat for all practical purposes means and includes all works department, Secretariat, including Water Resource
You
Department.
are reading in page number?
Page 73, my lord. Para 3 of the additional affidavit.
No, the numbers are not telling.
my lord, something, my lord, after the running, this, it's an affidavit in additional affidavit filed by Dinesh Kumar Singh. May I assist? Yes. I think the page numbers are changed after filing it, my lord. This affidavit, lordship will kindly come para 3.
Yes.
That the deponent begs to state that as per rules, Rule 2, Roman 2 of the Assam Grade 4 and Record Supplier Service Rules 1963, Assam Secretariat means all departments of the Secretariat, including Chief Minister's Secretariat, but excluding PWD Secretariat. An appointing authority as defined in rule is the Deputy Secretary of the Government of Assam, Deed and Secretariat Administrative Department, now General Administration Department. Since earlier PWD Secretariat was situated in a different campus outside the disposed Secretariat, therefore there was no bar for Public Works Department in making appointment, promotion, etc. in various posts of Grade 4. The Public Works Department was later on divided into another 3 works department, namely Public Works Department, Irrigation Department, Water Resource Department. The PWD Secretariat for all practical purposes means and includes all works department, Secretariat, including Water Resource Department. Since PWD Secretariat was excluded by the rules, so far as it relates to appointment of Grade 4 staff by the Secretariat Administration Department, now GAD, and therefore the Works Department were making appointment in Grade 4 post against substantive vacancies. It is under such circumstances, the petitioner was initially got appointment as peon in the erstwhile Millard Water Resource Department, now para 4. As per Rule 2, Note 5 of Assam Secretariat Subordinate Service Rule 1963, Secretariat means the department of the Government Secretariat, including Chief Minister's Secretariat and Public Works Department. Here in the Subordinate Service Rules 1963, the Public Works Department is included within the meaning of Secretariat. Therefore, appointment and promotion of Grade 4 employees of all departments stroke Secretariats of Assam Secretariat to the Grade 3 post, including the post of Junior Administrative Assistant, will come under the purview of Secretary Administration Department, now GAD, by following the provisions of Subordinate Service Rules 1963. A bare perusal of Sub-Rule 3 of Rule 8 of Subordinate Service Rule 1963, which provides for appointment to lower division assistant by selection from among Grade 4 staff and record suppliers of the Secretariat, clarifies that the Grade 4 staff and the record suppliers of all departments, Secretariats of Assam Secretariat, has to be done by the Secretary Administration Department, now GAD. Since Public Work Department has been included within the meaning of Secretariat in the Subordinate Service Rule 1963, therefore Grade 4 employees of Water Resource Department of Assam Secretariat bifurcated from PWD shall have to be considered for promotion in the Secretary Administration Department, now GAD. The respondents precisely following the above position granted appointment promotion to several similarly situated persons of the Water Resource Department to the post of JAA and SAA in the Secretary Administration Department. If your lordships kindly.
Where is Mr. Would you find him?
I'm sure lordship will left, Lord.
He left. So your stand will be he is not Secretariat Service. But then
That is
Mr. Goswami has to answer.
Lordship, but only question, Lordship, whether that 12 notification can be relaxed or not. That will be my only submission, Lordship.
No, you have to either say he's covered by this rule or you have to say he's not covered by
Lordship,
this.
even if your lordship holds that his service covers under the secretariat service lordship, that requirement of graduation lordship. Lordship will have to decide that.
That
lordship.
can't be, supposing we don't hold it, then why should we go into that? But the department has to say where is your appointment order?
Lordship will kindly come. My initial appointed by Water Resource Department.
Lordship is in court
Under-
number 1 lordship. He'll come.
Page number?
Page 14 of the writ petition, my lord.
Yes, ma'am.
14, 1. The erstwhile flood control department.
So this appointment order is a water.
Flood
resource-
control, under the grade 4, my lord, this is a separate rule. Record suppliers and grade 4, 1963 is a separate rule. In that rule, PWD was not included. That's why our appointments were made under that rule. But when we come to the next higher post of junior administrative assistant, 1963 rule in the definition included the public works department. That's how we come under. And respondents, my lord,
So in any case, we can't close this matter today because Mr. Goswami is not there.
Goswami is coming, I think, my lord, he's in court number 1.
Yes, Lord. Appearing lordship.
Well, I'll just place the facts, my lord, before your lordships in a
But we'll not close the matter today.
lordship.
You want to argue, you argue, but we'll
No,
not
no.
close it today. We
Obviously,
can have it on Thursday.
Thursday,
I also need to do some personal research on this.
lordship, lordship.
I'm not,
Otherwise, my lord, 2 things I'd like to clarify. First thing is that the contention, because the ground on which they rejected my case in the affidavit or in the pleadings, they say, I don't belong to JD or SAD department. That is their main ground. Now, subsequent amendment rule ground that has come later on. That is not in the part of the affidavit also. Now, only on that ground, they have rejected my case. My lord, I have annexed orders of issued by the respondents, promotion orders, wherein water resources department, flood control department employees, peons, grade 4 employees were promoted to the junior administrator. Those orders are there. So their stand is contradictory. So far as this ownership, my ownership is concerned. On the last occasion, Mr. Goswami appeared, your lordships paused the query that who will consider? Then very fairly, Mr. Goswami accepted that it has to be by the GAD. Because this question came in the
Mr. Goswami accepting that it will be by another person
no,
is no
that-
acceptance.
no. Not only that, because this same
Mr.
question was,
Goswami can accept that it is water.
I understand, Miller.
You
I
cannot
understand.
accept it is somebody.
All right, Miller. Let us forget about this. Same objection was raised in the case of my junior who got promotion before this honorable court. Then the department filed a writ appeal. In that case, the writ appellate court remanded back the matter to the single judge. In that case, the water resource department, PWD department filed an affidavit, said that my that person's promotion has to be considered under the 1964 rules, because PWD in the definition, PWD department was included in the rules of 1963. So far as this objection is concerned, that I belong to whom, absolutely there is no iota of doubt, my lord. And so far as, my lord, applicability of the amended rule is concerned, my lord, already there is a judgment of this honorable court wherein I was a petitioner. Out of 9 persons, I was a serial number 9 petitioner. This honorable court considered, send back the matter to the respondents to take a call that how many vacancies are there prior to coming of the rule, and whether they can fill up the post by clubbing up of vacancies or year-wise they have to fill up. They took a conscious decision by passing an order that there were 9 posts prior to the rules, coming of the rules, and those 9 posts they have filled up by 8 persons. 1 post they kept vacant because they did not promote me. The persons, the petitioners who were above me in the writ petition, all got promotion. I was excluded only on this ownership ground. That is the case. And my junior who came later approached this.
Well
honorable court.
understood. We'll have it on Thursday.
Lordship,
That is
all right.
15th. 15th, heard Mr. H.K. Das, counsel for, he does not counsel for the petitioner, also heard Mr. E. Nayak, Leonard, standing counsel, GAD. Assam. It is submitted at the bar that Mr. B. Goswami, Leonard, additional AG Assam, appearing for the Water Resources Department, is on legs in another court. First of, in view of the above and on the request of Leonard Department Council, further hearing of this matter stands deferred till 16th of June 2023. This is again as a fixed parted matter.
Deeply obliged.
Item 46. For hearing item 46.
Is anything surviving in this case?
I think Lordship, it is 2012, he was removed from service under charge of biogamy. And he also admitted it that he has contacted second marriage.
None appears for the writ petitioner when the matter is called up. Ms. R. Devi, Lanet CGC is present on behalf of the respondents, full stop. It appears that the petitioner's counsel was not only absent on the previous occasion, but the learned counsel did not appear on earlier occasions as well. Be that as it may, the writ petitioner herein was serving as a CT/GD under the Sasastra Seema Ball within bracket in short SSB bracket close, was removed from service by the order dated 31/1/2012 on the charges of bigamy. Full stop. His appeal preferred against the order of removal from service was also rejected by the appellate authority. Aggrieved thereby, the present writ petition has been instituted. First up, the petitioner is admittedly out of service since more than last 11 years. It appears that due to long lapse of time, the petitioner has lost interest in pursuing the matter. As such, this writ petition stands dismissed for non-prosecution. Then you write, it appears that it appears that the petitioner has admitted the charge of bigamy. Then it also appears that due to long lapse of time.
May I please, my lord? My lord, I'm praying this matter may be fixed to my lord. My lord, this matter, my lord, at order dated 8/2 of
You are
21.
appearing for whom?
I'm on behalf of Mr. SP Chaudhary, my lord, for the Union of India, my lord.
But where is the petitioner?
My lord, on the order dated 18/2/21, there was a direction to produce the records, my lord.
Hmm.
Before 1:30, the CRPFs are supposed to give us the record so that the inquiry proceeding which was conducted
Hmm.
can be known. So, my lord, we are waiting for the records to come.
Okay, we'll post it next week. None appears for the writ petitioner when the matter is called up. Mr.
K. Vishwakarma,
K. Vishwakarma, learned counsel appearing
on behalf of
for the-
Mr. SP
on behalf of
Chaudhary.
Mr. SP Chaudhary, learned CGC submits that the records as called for by this court will be received during the course of the day, and hence this matter be posted again for hearing in the next week. Since the petitioner's counsel is absent today, the prayer stands alone. Registry to list this case accordingly.
Obliged, ma'am.
Okay, Lordship, this matter may be posted next week, my lord. I will file affidavit by Friday, my lord. It's ready, my lord. Maybe to some promotional matter. Other is ready, my lord. He will be coming tomorrow to swear the affidavit.
On the prayer of Mr. Vijay Ghosh, learned counsel for the petitioner made with the consent of the other side. Hearing of this matter stands adjourned for 10 days so as to enable him to file an additional affidavit.
My lord, yes, Lordship, we'll file it by day after.
List this case accordingly. Yes.
My lord, next week, my lord.
Lordship, item number 47, finally, my presence may be recorded, Lordship. Item 42.
Next week,
Please appear,
next week.
Lordship.
You are not there. I passed the order because you are not there. Now, how can I record your presence? Yes.
May I start, your lordship? I would-
What is this matter about?
Matter relating to my lord, the petitioner who is serving in Assam Meghalaya cadre as an IPS officer, he applied for deputation in enforcement director. And at the time of taking decision, my lord, enforcement director has not taken into consideration policy decision. It is especially meant for Eastern officers, my lord, who served 10 years in Northeast. Whereby, my lord, it is mentioned, my lord, that extra weightage and priority should be given to the officer who serve in the Northeast. And there should be exceeded by the authority as per the policy, my lord. That has not been taken into consideration by the authorities while taking into decision so far as petitioners are concerned. So mainly, my lord, two questions arises for determination before your lordship. First is, my lord, whether at the time of considering my candidature, respondent ED has complied with the direction given in the policy decision dated 18/2/2009. Second, your lordship, whether what are the method and mechanism ED adopted in giving, my lord, extra weightage and priority to the petitioner while considering his candidature for the deputation in ED, your lordship. My lord, I am challenging the decision-making process.
But you are now out on deputation already.
I am now working in, my lord, Competition Commission as additional director, your lordship.
Your tenure is for how long?
For 3 years, my lord, 2 years already completed, my lord. And deputation, total deputation period is, my lord, 5 years, and it can be extended to 7 years, your lordship. So far as my entry in ED is concerned, my lord, this is called my lateral shifting, your lordship. That I notification.
So if you succeed, they will shift you
My
from here to there.
Lateral, this is called lateral shift.
Is it permissible?
That reply I have annexed.
My lord,
All right, we'll take it up.
thank
at
you,
two.
my lord.
So your client wants to go on deputation to the, and he has not been selected.
Not been selected.
Now, can you force your way into somewhere where they don't want you?
My lord, I am not on that. What I am submitting before your lordship, the decision-making process, your lordship. Whether the authority at the time of my lord taking into consideration of candidature of all the candidates, my lord, whether the authority has taken into consideration the my lord policy, which your lordship will find at page 49 of my writ petition. And whether the authority has on the basis of this policy developed, adopted a mechanism, method. This is the question, my lord. It may not be that, my lord, I will be selected, your lordship. Page 14.
49.
49 of my writ petition, my lord.
Is some judgment.
49, my lord, it is running with writ petition, it is annexed as annexure 8. Page 49. I think your lordship is affidavit, your lordship may file by them, they have annexed.
It's page 49, all right.
Page 14. This is the, my lord, root of the case, your lord.
Please read it.
My lord, may I start, your lordship?
Yes.
Subject, incentives for all India service officers serving in the northeastern states. I am directed to state that as a part of central government's policy to provide incentives to the officers of all India services serving in northeastern region, the following measures have been approved by the competent authority. In order to attract officers of Northeast to come on central deputation, additional weightage and priority be given for empanelment and for central deputation for officers who have spent at least 13 years in Northeast cadres. Thereafter, officers of Northeast will be given priority for foreign assignment. This is not applicable. Next, your lordship. Officers of Northeast cadres would be provided facility to indicate their domain preferences based on their experience for central deputation in Government of India. Efforts shall be made as far as possible to accede to their requests.
So your grievances while considering your client's application,
My lord.
this policy was not followed.
My lord.
What do you have to say on this? How many posts were there total?
Initially, two advertisement passed for 2 posts. Subsequently, my lord, they have advertised in supersession of my lord earlier notification saying that for 5 posts, saying that earlier 2 posts shall also included in the subsequent notification, and the candidate who has applied for 2 posts shall be considered in the my lord second one notification. Accordingly, my lord, I have moved before this honorable court, and
where is the advertisement?
That your lordship will find at page 25, my lord. Annexure 1. May I read your lordship?
Yes.
Filling up of the post of additional director of enforcement in Directorate of Enforcement on deputation basis. Applications are invited from eligible candidates for the post of so and so on deputation in Enforcement Directorate against the vacancies at Chandigarh and Kolkata. My lord, this is the notification. Accordingly, I applied, my lord.
And then when is subsequent one?
Subsequent, my lord, I'm coming, your lordship. That your lordship will find at page 37, my lord. 37. November 2019. In supersession to the vacancy circular dated so and so earlier one, by which vacancies in the grade of additional director of for Chandigarh and Kolkata were advertised. Applications are invited from eligible candidates for the post of additional director for enforcement in so and so on deputation basis in the enforcement directorate against the enforcement director against the 5 additional vacancies in the grade of additional director. Application already received against the previous vacancy circular dated so and so would also be considered for all the vacancies.
So your client had applied pursuant to the first advertisement.
First and second as well as my second also I applied, and the
So
odd if you
where is your statement that they have not followed the policy
that
guidelines?
my lord, that time I can your lordship may kindly see.
There are numbers.
I am coming, your lordship. Page 12, my lord, it starts from para 4. And your lordship may kindly come to page 13. The eligibility and company of the petition in as much as 5th line from top, 6th line from top. Respondent number 2, while recommending the names of the candidates for the post, has not taken into consideration the policy decision dated so and so taken by Government of India, whereby in order to attract all India service officers from Northeast to come on central deputation, additional weightage and priority be given for empanelment and so who have spent at least 10 years in Northeast. In the present case, no weightage and priority was given to the petitioner who has successfully completed 13 years in Assam, while recommending the names of officers for the post of additional director of enforcement on deputation by the respondent number 2. Thereafter, submissions are there.
So where is their reply to para
Lordship will find it.
4?
Paragraph 24 and 25 of my counter affidavit.
Paragraph 24 and 25.
Lordship.
Twenty-one also.
It starts at Lordship, page 17C. But so far as the policy decision is concerned, Lordship,
And what are the stands taken in point A and B?
Lordship will see my reply at Lordship from page paragraph 9, so far as A is concerned, and B, Lordship 18.
Is para page
Affidavit page 10.
25F of the CVC, where is the 25F CVC? That is a part of the record.
Lordship, I have copy of the series. As an copy.
Now, was weightage given to him as per the policy decision?
Lordship, since the DOPT Secretary CVC Commission, they were aware of this policy decision. Therefore, Lordship, my submission would be, they had the knowledge and weightage, Lordship, is like, I do not find anything that extra weightage has been given, but it's a policy decision, and when our stand is 25F, Lordship, this policy decision may not be applicable, Lordship. Asanigit? Huh? No, sir.
CBC Act.
Your client is presently where?
My lord,
Yes,
presently he is in Delhi,
Competition Commission.
Competition Commission as Additional Director General. CBC Act is me.
ActCom. ActCom. CVC ActCom.
In fact, same question came up before my lord, Honorable Apex Court, my lord, regarding policy decision. May I place my Apex Court says, my lord, government should not, department or different, my lord, the government of India should not speak in two voice. And when the policy says it has to be complied with, my lord, that decision, my lord, Lloyd Electric and Engineering, my lord.
Lordship will also find it in
Where is
the
the record? Do you have
writ
the record?
petition.
Do you have the record?
Writ petition, Lordship, page 33 there. I mean, the affidavit in opposition, Lordship, page 33 is annexed, Lordship.
So this CVC rules 2003 were followed
Lordship.
while selecting. And there was a selection committee
Yes, yes.
headed by
Lordship, by the CVC Commissioner, Lordship.
Central Vigilance Commissioner. Chairperson is my lord, Central Vigilance Commissioner, page 9.
it's a 3-member committee.
My lord,
3-member committee.
my lord, here your lordship, total
I-
five member, your lordship. They have
I have got a
minutes, my lord, meeting was held on. Meeting was held,
I've got a minus of the committee, Lordship,
on 19/10/2020.
it was
1910, 2000.
19/10/2020. Makos. May I read it, Lordship, the first paragraph?
Yes.
A video conferencing meeting under the chairmanship of Central Vigilance Commissioner was held on 19/10/2020 at 3:30 PM to consider the applications for selection of 7 posts of additional director of enforcement and to recommend 7 most suitable candidates for the posts on deputation. Following members of the committee attended the meeting. There were 2 vigilance commissioners, then the Home Secretary and the Secretary of Finance were there. And if I may take your lordship to paragraph 5 in the next page. Of the 17 applications received, it was informed that 2 applications were withdrawn, serial number 6 and serial number 7, and 1 application was received late, that is serial number 8. Thus, the remaining 14 applications were considered by the committee. Certificate regarding eligibility, APAR, gradings, and vigilance clearance and receipt of applications before the due date was perused by the committee. The committee considered the history of postings, previous experience, vigilance status, PA grading and choice of postings, etc. of the 17 officers. After detailed deliberation, the committee recommended the names of the following 4 officers for appointment on deputation to the post of Additional Director of Enforcement for a period of 4 years, including the period that the officers has already spent on deputation to central government immediately prior to this appointment. So 4 names were recommended, Lordship.
So there are 2 posts still vacant.
3 posts. One is my lord kept vacant because of dishonorable.
One by virtue of the sports order.
So what is there? See, the court will interfere if there is a violation of Article 14. Otherwise, what
In the
business?
minutes, your lordship will find not a single whisper about the policy, your lordship. And my lord,
There is no need.
My
I
lord-
said there should be loud whispers about policy.
my lord, unless and until, my lord, if the policy has been framed for the officers of not serving in Northeast, that if they considered it, thereafter rejected, my lord, I have no case. Your
Policy,
lordship.
they were aware of this. That's what he
They are saying, but there is nothing on record, your lordship.
This matter cannot be raised.
My lord, in my affidavit in reply, I have submitted your lordship. And my lord, policy decisions, my lord, it is my lord. In case of my lord, Lloyd Electric Engineering Limited. Apex Court held, my lord, it is mandatory, your lordship. Not a single line they have written, my lord, regarding, this is our case from very first day, your lordship. And that's why this honorable court was pleased to, my lord, keep 1 post vacant, my lord, and directed them to produce record. So in my humble submission, my lord,
So far as Lordship, this 25 is concerned, Lordship, and other policy decision, I've annexed a judgment of the Honorable Supreme Court at Annexure 5, page 58. Where in paragraph 5 that your Lordship will find at page 16.
Yes.
We are of the considered view that a statutory rule can never override a legislative enactment. And as such, the date of superannuation would have no consequences whatsoever with reference to clause so and so, which is explicit and clear. Additionally, the learned counsel are fully justified in pointing out that section 25 extracted herein above postulates that the aforesaid provision would have an overriding effect above any other law for the time being enforced. The aforesaid mandate contains in section 25 of the Act leaves no room for any doubt that even if there had been a legislative enactment to the contrary, the instant provision mandating a period of not less than 2 years from the date on which the incumbent assumes office could not have been varied. So, Lordship, the argument, Lordship, advanced by my learned friend, Lordship, in so far as the rules are concerned, Lordship, I do not think, Lordship, that will hold any water, Lordship.
my lord, one decision, your lordship. Para 14, your lordship. Regarding Article 14, my lord, in my reply, I have stated, your lord. Para 14, your lordship, may kindly see. Page 564. May I read, my lord? The state government cannot speak in 2 voices. Once the cabinet takes a policy decision to extend its 2004 industrial policy in the matter of CST concession, so and so, and a notice accordingly having been issued by department concerned, Department of Industry, thereafter the Excise Department, cannot take a different stand. What is given by right hand cannot be taken by left hand. The government shall speak only in 1 voice. It has only 1 policy. Department are to implement government policy, not their own policy. What I am submitting, my lord, it should be read along with policy, my lord. I am not saying it should go contrary to the policy. The policy decision taken by my lord, Government of India should, my lord, in my humble submission, and regarding their, my lord, that I am not, that in my reply, my lord, I have elaborately mentioned, your lordship, that your lordship will see. my affidavit in reply filed against their page 79, my lord, para 20. Before that, my lord, regarding sufficient expense, para 15, page 71. Something they
So,
develop, my
Mr.
lord.
Goel, what is the point you are, what is the law point you are arguing?
My lord, my
What
lord,
is the law
there,
point?
my lord, what I am submitting, my lord, whatever the decision they may take, this is the authority. But there should not be any arbitrary and there should not be any violation, your lord.
So how is it arbitrary? How-
Arbitrary,
How is
they
the
are saying, my lord,
decision?
sufficient experience and all.
Hmm.
That I have placed page 71,
Yes,
your
yes,
lordship.
yes. See, you want to go to somebody else's house, correct?
True, my lord.
Deputation is when you are
True,
going
your
outside your cadre.
My lord.
Can you force your way into that house?
No, my lord. What I'm
Only if there is a discrimination that on the same touchstone, somebody else has been given a upper hand, a heads up, and not you. That would be a colorable exercise of power.
here,
Otherwise, on a complete assessment of merit, they don't want you.
I
Then
will
the
not
court
go, my lord,
force
but
them
so
to-
far as, my lord, for the officers serving in Northeast, why discrimination with those officers
Things are to promote so that they come forward and apply for
I-
deputation.
in policy?
You are trying to push your
My
way
lord,
into
it is,
deputation.
it starts from, it is directed, my lord. The wording is directed. Para 15, your lordship. I have given I have conducted a number of cases, including PMLA cases, my lord. I am one of the finest officer,
That is
my lord.
another matter.
And regarding dear, my lord, paragraph 21 reply, my lord, I have given, my lord, that your lordship will see at page 79, para 20.
The resolution dated 1910 is not under challenge.
Lordship,
Resolution of the
No.
committee is not under challenge.
No, that was not with us, my lord. They are not disclosed. It is there. This is the internal thing, my lord. In fact, in affidavit, they have not filed. If they would have filed it, then I can challenge it, my lord. First time they have shown before this honorable.
2/11/2020. Where is 2/11/2020?
Lordship,
2/11/2020. The impugn order dated 2/11/2020.
My lord. Page 40, my lord. 48. This is the, my lord, 4 officers. Selection of 4 officers.
ठीक है, sir.
Here, out of 7 posts, they have selected 4. My lord, like Karbi Angalam incident, my lord, I was the supervisory officer.
Mr. Goel, I am surprised that you are going here and there.
My lord,
If I write all these things in the judgment, there will be serious trouble for you.
My-
You are asking the court to pass a judgment
My lord,
whether he is.
I am confined to policy, my lord. If your lordship feels that,
You have done it already.
my lord,
The court is not convinced.
my lord, it is my
Let
lord.
me
I am
now
giving
dictate.
to your lordship, my lord.
Heard Mr. A. Goel, learned counsel appearing for the writ petitioner. Also heard Mr. R.K. Dev Chaudhary, learned DSJ appearing for the respondents. The petitioner herein is an Indian Police Service officer, bracket Indian Police Service, bracket IPS officer of the 2005 batch with his allotment to Assam Meghalaya cadre. Full stop. As per the case projected in the writ petition, the petitioner has served as an IPS officer with distinction and without any blemish to his reputation. Full stop. On 29/8/2009, the Government of India, Ministry of Finance, Department of Revenue had issued an office memorandum inviting applications for filling up 2 posts of additional Director of Enforcement at Chandigarh and Kolkata on deputation basis. Full stop. In response to the OM dated 29/8/2019, the writ petitioner had submitted his application. Full stop. Subsequently, OM dated 4/11/2019 was issued by the GOI, Ministry of Finance in supersession of the earlier OM dated 29/8/2019, thereby expanding the total number of posts of additional director of enforcement to 5 posts. Full stop. In the OM dated 4/11/2019, it was mentioned that applications received by the department under the earlier OM dated 29/8/2019 will be considered for the aforesaid vacancies. Full stop. The procedure for selection of additional directors in the Enforcement Directorate is laid down under the Central Vigilance Commission Act 2003. Is laid down under selection and appointment of additional director of enforcement is laid down under Rule 25 of the Central Vigilance Commission Act 2003. Full stop. As per the provisions of Rule 25, a 5-member selection committee headed by the Central Vigilance Commissioner is to conduct the selection process and make recommendations. Accordingly, a 5-member committee headed by the Central Vigilance Commissioner as its chairperson was constituted. Full stop. The said committee had considered the 17 applications which were found to be in order. Full stop. Upon such consideration, the names of 4 candidates, 4 applicants were recommended. Just wide minutes of the meeting of CVC held on 19/10/2020. Full stop. The consequential notification dated 2/11/2019 2/11/2020 was issued. Where is this 2/11/2020? Page number?
Annexure 7.
Page 48,
Page 48.
this is the impugned order, madam.
Was issued by the Under Secretary to the Government of India, notifying the names of the 4 selected candidates. Full stop. At that point of time, although there were 7 vacancies in the post of Additional Director of Enforcement, only 4 vacancies have been filled up. Full stop. Aggrieved by the aforesaid decision and recommendation made by the selection committee, the petitioner has approached this court by filing the present writ petition, inter alia contending that the selection committee did not take into account the policy decision
Page 49.
of the Government of India notified by circular dated 18/2/2009, wherein certain special provisions have been made for officers from the northeastern region so as to encourage them to go on central deputation. Full stop. Taking note of the grievance expressed by the petitioner, this court had passed interim order dated 18/11/2020, directing the respondents to keep one post in the rank of additional director of enforcement to be kept vacant, awaiting final disposal of the writ petition. Full stop. It appears from the materials on record that during the pendency of this writ petition, the petitioner has gone on central deputation and is posted as additional director in the Competition Commission of India. Competition Commission of India. is it?
Competition Commission.
At New Delhi, with his term of deputation of 3 years. Full stop. Mr. Goel submits that the petitioner has 1 more year to go as additional director of Competition Commission. Full stop. Full stop. Next, the learned counsel for the petitioner has addressed elaborate arguments in support of his contention that once there is a policy decision of the government of India, the same ought to have been adhered to scrupulously by the Selection Commission, which was not done in this case. Full stop. Mr. Goel submits that had the Selection Commission as well as the Director of Enforcement taken note of the policy decision of the Government of India as notified on on 18/2/2009, the petitioner would have fared well and in all probability would have been and in all probability his name would have found place amongst the selected candidates. And stuff. Contending that the respondents cannot take a stand which is contrary to the policy decision of the government. Mr. Goel has referred to the decision of the Supreme Court rendered in the case of Lloyd Electric and Engineering Limited versus State of Himachal Pradesh and others, reported in 2016 bracket close 1 SCC 560. The petitioner's case has been contested by the respondent number 3 by filing affidavit wherein affidavit primarily taking 3 grounds. Firstly, that the circular dated 18/2/2009 has been duly considered by the committee while conducting the selection process for appointment of additional directors in the Directorate of Enforcement on deputation basis. Secondly, the decision taken by the committee in its discretion conferred under Rule 25 bracket F of the CVC rules of 2003 is not subject to reversion in an appeal, more particularly in exercise of jurisdiction under Article 226 of the Constitution of India. Full stop. The third ground taken by the respondents is that there is no illegality in the selection process, and as such, there is no right of the petitioner which can be enforced in this writ petition. First stop. In order to examine the contention of the writ petitioner, this court has gone through the minutes of the CVC meeting held on 19/10/2020 and finds that the committee has scrutinized the applications submitted by all the eligible candidates, including the writ petitioner. And after making a proper assessment of their candidature on a numerous touchstone, the 4 best officers had been selected and recommended for appointment as additional director of enforcement on deputation basis. The selection, the minutes dated 19/10/2020 does not record any negative entry against any of the applicants, but merely seeks to choose the best 4 amongst the applicants before the commission, full stop. The exercise of jurisdiction by the selection committee not only appears to be fair and transparent, but is also in consonance with the mandate of Rule 25 of the Rules of 2003, full stop. Full stop. It is no doubt correct that there is a policy decision of the Government of India notified on 2009, laying down the following 3 aspects to be taken note of while considering the applications of the officers serving in northeastern states for on deputation basis. Full stop. The 3 factors highlighted in circular dated 18/2/2009 are reproduced here and below for ready reference. You'll find it in page 49 of the writ petition. A plain reading of the aforesaid conditions would go to show that the same are aimed at encouraging officers from Northeast to come for central deputation by giving additional weightage and priority for their empanelment. In case of those officers who have spent at least 10 years in Northeast cadre, full stop. There is no reason for this court to presume that the selection committee was unaware of the policy decision of the Government of India as notified by the circular dated 18/2/2009. Moreover, I find force in submission of Mr. R.K.D. Chaudhary that that Directorate of Enforcement being a premier agency, the question of appointment of additional directors therein would ultimately depend on merit and overall suitability of the officers, which the selection committee would be the best judge of, and therefore it is not for the petitioner to point out the parameters on which such selections are to be held. Full stop. After a careful scrutiny of the materials available on record, I do not find any element of discrimination or arbitrariness in the decision-making process leading to the recommendation and appointment of as many as 4 candidates as additional director of enforcement on deputation basis. Full stop. The decision next, the decision rendered in the case of Lloyd Electric and Engineering Limited, bracket Supra, as referred to by Mr. Goel, no doubt lays down that the government must adopt a consistent stand and comply with the policy decision of the cabinet. Full stop. However, the aforesaid decision was rendered in the context of implementation of the 2004 industrial policy in the matter of CST concessions to the eligible units. Full stop. Therefore, the aforesaid decision is rendered in the facts and circumstances of this case, which in the opinion of this court would have no bearing in the facts of the present case. Stop. uh, the matter would have been entirely different if the stand of the selection committee or the respondents would have turned out to be contrary to the policy decision of the government of India, which is not the case in hand. For the reasons stated herein above, I do not find any justifiable ground for this court to interfere in the matter. This writ petition is therefore held to be devoid of any merit, and the same is accordingly dismissed. Interim order passed earlier shall stand vacated, and in view of this suit order, IS stands disposal.
Lordship, may I just, Lordship has stated rules, it will be section.
Section, not rule, sections.
One thing is your lordship, my lord, your lordship,
Well, you have tried.
my lord. So far
Let
as
us do our job.
my lord, section 25 is concerned, my lord,
You cannot force your way
My
to
lord.
somebody else's house.
my lord.
Come up
Minutes-
with such a dossier that they'll bend the rule to take you in.
But only one thing,
You are
only
trying to do something else, bend the rule to go inside.
clarification only for my lord.
Hmm.
In the minutes of meeting, my lord, only 4 members were there. There was no chairperson. So it was 25, my lord, it is not there.
You have not read it properly.
By VC.
Chairperson is in first line. The 4 persons are only names of the members.
My lord, it is
That is
required.
the
my-
problem with your client. He doesn't
Copy,
read the entire
copy has
document.
no, my lord, I am taking copy from London. This is required, my lord.
It's all right. You have done your job. You have done your job. You have tried.
I am deeply obliged.
But this is the view of the court.
My lord, I am copying, taking copy of.
I will
minutes,
give him
my
a copy, Lordship. I am not denying him a copy. I'll
Give him a copy that
I'll
will
give him a
help him.
lord. For my
Yes, yes.
education
No, no,
purpose,
For further case.
deeply obliged.
All right.
I am grateful to you.
But CBC was there. First line
My
says,
lord, I am sorry, my lord, extremely.
all right.
Photocopy করে দিয়েছে।
Yes, yes, next matter, please. Yeah. Hmm? Yes, part 2 matters.
Miss, please, Lordship, can this matter be fixed on the?
This
on
matter was
Thursday, my lord?
dismissed for default yesterday, then a
Actually,
request
due
was
to
made.
of personal difficulty, my senior cannot do this matter today, my lord. I'm praying that matter be fixed on Thursday, my lord.
Mr. B. Chatri is appearing in this.
Yes, I'm appealing on behalf of B. Chetri, my lord.
Where is he?
He is on Lex, my lord. So, my lord, if possible, this matter may be fixed on Thursday, my lord.
This matter will be taken up on Monday. But you must tell him that he had, this order of dismissal for default was recalled on an assurance that he will argue the matter today. These are not good practices.
My lord is my lord is fixing the matter on Monday, my lord.
Monday.
Oblige, my lord.
May please your lordship. Well, this petitioner, Damoli Chetri, widow of the person concerned who is missing, and the Joy Chetri, who was working in the SIB and was posted at Kokrajhar, under Rugia. He was on the fateful day, he was sent with a mail to other office, outpost office, but unfortunately, this man did not return on 3/2/1989. And since then he was missing, and department has lodged an affair in 2008, my lord. That also I have annexed. Thereafter, mother also lodged an affair after long delay, my lord. And in the meantime, my lord, since nothing was found, there is a report from the police officer that it is strongly suspected that he might have been killed by the extremist in Kokrajhar. At that time, Bodo agitation was going on. This man, being a part and parcel of the intelligence department, he was missing, my lord. He was sent with a mail. But my only prayer before your lordship, since mother has not come in time, because mother is at Dhekiajuli, Borsola. He was at Kokrajhar, my lord. So mother had no news, but mother, since he was absent long, mother inquired, my lord. Then came to know from office that your son is not coming to the office and his whereabouts is not known. Then he lodged the affair after a long gap, my lord. And on that affair, the police has given a report, my lord, that he is strongly suspected that we have tried our best to find him out, but we could not trace him out. But it is strongly suspected that he might have been kidnapped by the extremists.
All right, so what is
Now,
the release?
my prayer before your lordship, my lord, in the meantime, my lord, in an ex parte departmental proceeding, he was dismissed from service because of his long absence in the department. And I am nothing to be challenged by. Many is no more in this world. Now, it is more than 20 years, my lord, he deemed to be dead. But his retirement benefit, whatever he did, for 10 years, sir, he has more than 10 years, he was served. Then that retirement benefit, they are denying, they are not paying.
You are appearing in this case. A man gone missing, suspected to have been killed by terrorists, he is dismissed from service.
No, Lordship, that is not the truth. Inquiry proceeding was initiated. He was once appeared, but subsequently he was not appeared. Then he was attached to his Rongya office in dark duty, from where after completing that 1 week period, Lordship, he never returned back to the office. And that departmental proceeding, that which is continuing, and he had never appeared, that was on that disciplinary proceeding, he was dismissed for absent, Lordship, without any intimation, Lordship. It's not that because of he was missing, he was dismissed. That is not the correct thing.
No, departmental proceeding was done ex parte because no notice could have been served to him.
So where is the order of dismissal?
Now, my lord, my prayer is that whatever the dues entitled by widow mother is 80 years above old man, that should be paid.
No, order of dismissal, where is it? It has to be set aside first.
From their affidavit, my lord, it just come, my lord.
Here their prayer is to retirement benefit as well as to appoint the brother of the petitioner on compassionate ground. Firstly, Lordship, the petitioner was in fact appointed on compassionate ground, Lordship. He is a habitual offender of not regularly doing his service, Lordship. We had in our affidavit also stated that 4 or 5 times he had unauthorizedly absented, Lordship. And for that disciplinary proceeding was going on, Lordship. And here, Lordship, they are asking for pensionary benefit also, Lordship. That is also not possible because we have annexed that he was married. And when his wife or children is there, in that case, only the wife or children is the dependent.
But is the wife and children getting the pensionary benefit?
No.
Because
sorry, my lord. He was never married, and it has been denied by us in our reply. And they have projected a lady, my lord, that he was a married man. She never came to claim anything.
Will you allow the judge to speak? If you do it with your permission.
Yes, my lord. Let my say. Thanks.
Is anybody receiving pension on account of the missing?
she had never claimed, Lordship. Wife never
Then
claimed.
who is getting the pension? Who said wife is getting?
Yes,
pension?
Lordship. While wife is entitled, Lordship.
But are you paying pension to anyone?
She have never came to us, Lordship, because and more so, Lordship, his past services forfeited under Rule 26, Lordship, when he was dismissed for unauthorized absence, Lordship.
What is the date of his dismissal?
Lordship, 14/5/99.
And since when did he go on missing?
Lordship, from
3 to 89.
No, Lordship.
Yes.
3/12/89 he was appointed.
No, 3 to 89. He was appointed. He was missing from 31/7/98. 31/7/98. From their own Ejahar.
So when the order of dismissal was passed,
Yes, Lordship.
he was either missing or dead. There is a possibility that,
Or that missing or dead, that is.
listen, so that you can come prepared and answer the question of the court. You have the temperament to first understand. If the petitioner's son was not seen or heard of since 31/7/2008, then as on today, it can be presumed that he was dead on that day. Therefore, you passed an order of dismissal against a dead person. What is your justification for doing that?
Lordship, the petitioner son was from 31/7/98, he was deputed to Rongia for official dak. Thereafter, he has never returned back to his duty, Lordship. And as he was a habitual to that, Lordship, no Azahar, nothing has been filed, Lordship, by any of his family members, nothing. So we are on presumption that as usually he had never returned back an unauthorized absence, he is continuing, Lordship. The Azahar was lodged up in the year
Mr. Biswas, the problem is,
2008, Lordship.
the problem is, if the missing son was married,
My lord, it is a false matter. She never came to claim anything. That
how do you know he is married?
That we in our affidavit we have
in
annexed
that
one.
their affidavit, we know from their affidavit only. That he married, my lord,
There is one,
from Lakhimpur, a lady from Lakhimpur.
yes, Lordship. Name is also given, Lordship, but they have never.
My lord,
Even-
with all humbleness, I would like to bring your notice. Well, a department has got duty that a man is missing from my office and he is working in an intelligence organization, SIB, Subsidiary Intelligence Bureau. At that time, activist movement is going on in entire Bodoland. My lord, was it not the duty of the authority to immediately lodge the affair? They lost the affair after 10 years, 2008.
Ms. Sharma, this writ petition cannot be dismissed on these facts.
Lordship may kindly have to see, Lordship, the fact of the case, Lordship, before passing an order, Lordship. So Lordship may kindly take up my affidavit, Lordship. Facts we have stated in paragraph 5, Lordship.
Yes.
Paragraph, may I read, Lordship? 5A, Joyce Etri was appointed as security assistant in SIB Tespunon 3-89 on compassionate basis upon the death of his father so-and-so, who was an erstwhile employee of the respondent. At the time of his appointment, Joyce Etri so-and-so. B, Joyce Etri, while posted at BIP Huri, did attended his duties with effect from 1st December 96 unauthorizedly, and as such a disciplinary proceeding was initiated against him, and a charge sheet in relation to the same was also issued to him so-and-so by the order dated 29/5/97. Thereafter, inquiry officer and the presenting officer was appointed and proceeding was started. Accordingly, IO fixed 25/3/98 as the date of preliminary hearing in respect to the said proceeding. Joy Chetri attended the said preliminary hearing, which was held on the scheduled date, and partly accepted both the article of charges leveled against him. However, did not appear before the inquiry officer on or subsequent dates of hearing that was held on 27/4/98, 27/98, and 24/8/98, in spite of issuance of various notices. While the aforesaid inquiry was in progress, Joy Chetri was being transferred from Huri. Thereafter, Joy Chetri was deputed for dark duty to SIB Rongia on 23/7/98, where he continued to work in the said post till 30/7/98. However, on 31/7/98, Joy Chetri, after leaving the Rongia office along with the DAC, failed to report back to his duty thereafter and remained absent from duty thereafter till his dismissal from service. Meantime, the inquiry proceeding was decided to be conducted ex parte by the inquiry officer in view of the repeated failure on the part of Joy Chetri to attend the same. Thereafter, upon conclusion, inquiries were conducted. Inquiry officer concluded both the charges leveled against so-and-so has been proved. Subsequently, disciplinary authority, while acting upon the said inquiry report as submitted by, dismissed Joy Chetri accordingly on 14/5/99. So these are dates where he was not present, Lordship. The Azahar, so we are not aware where he was, Lordship, because after completing duty, he have never, it is not that he was missing from his office. In fact, he had not missing from his official duty also. He completed it. And the mother lodged the Azahar before the OC Rongia police station on 21/108. And what is their submission is that, what is their stand is that, Lordship, that she stays in Sonitpur and the petitioner was working in Rongia, so she was not aware for 10 years where her son is, Lordship. It's 2008. And then one document they have annexed from the OC that we could not trace him. So we are under the impression that he might have been killed. And when they had charged for the person after 10 years, if we take it as missing lordship from 98 to 2000, how could someone trace someone after 10 years of, if we take it as missing also lordship? And now they are claiming pension and also compulsory appointment in respect of the brother. He was a compulsory appointment.
That part you forget it,
Yes, lordship.
but how, the point is that he was dismissed from service on that day, he may not be alive.
He was absent, but the disciplinary proceeding.
Oh, you said he was
Lordship.
absent.
Yes,
You said he was, here went with a duck. If you repeat it 3 times, it is not going to better your case. All I'm saying is on the date on which the order of dismissal was passed,
lordship.
on that day, before that, he went missing. So there is a possibility that he was not alive on that date. What do you have to say on that?
He
He
was,
will be declared dead with effect from the date on which he went missing.
Lord,
Which is the provision? Which is the provision, Mr.? Missing person.
108 of the evidence act. Missing, I've got to go.
but he was reportedly, repeatedly absent lordship, that is prior to his death. The judgment 14,599, but the dates he was alive lordship.
Sorry?
The dates where he had not attended the inquiry proceeding, at that time he was alive. On
Correct. But then when the order was passed, he was not alive.
that is only their presumption that he had died. Our stand is that he was unauthorizedly absent lordship, so he forfeit the benefit of pension, etc.
We'll pass the judgment on Tuesday. You come prepared if you have anything to say. We'll set aside the order of dismissal. And your arguments are not convincing. You read 108 of the Evidence Act. It will be with effect from the date on which he went missing. 7 years he was not heard of by people who should have heard him about him, that is his mother. So that is presumed dead. You have to prove that he was alive on that day.
Yes.
Otherwise, the assumption will be he was dead. You cannot pass an order of dismissal against a dead person. That's the law. But you are obviously not ready with the submissions. You don't have the decisions.
They have, was it not their duty?
You do not have any legal authority on that. Is that correct? You don't have any decision to back up your.
I'll find out.
Find out that. Then
I'll
we'll
find.
pass an order. These are all submissions, but it should be backed up by.
I'll
some
give you
legal
lot of
authority. Yes. This is SIB, this is Union of India.
Yes. Subsidiary Intelligence Bureau.
Whatever happened while he was alive is one story. What happened after he was dead is another story.
I submit only the dismissal order is if we take the date of missing as his date of death also lordship, but the his
Please
failure
ask
to,
your junior to make a short list of dates.
I'll give you.
his failure to appear, that was at the time.
That is
of
correct, but you, supposing somebody commits a murder, can you convict him after he is dead? What is the law?
That is,
So is there, can there be anything more graver than committing a murder?
no,
Even that person you cannot
But
convict.
our stand is that he, whether he is dead or alive, that is also
All right,
not, he is.
We'll reject it by a proper explanation. That is no stand.
My
That
lord,
is,
my
that is
only-
not based on analysis and understanding of law. That
My-
is just you are saying off the cuff.
My only submission before that, they being a subsidiary intelligence bureau, they are top intelligence organization of India. They ought to have filed a FIR that man is missing. He went with the dark, my lord.
You cannot pass an order of dismissal against a person who is presumed to be dead on that day. That's the end of the matter.
Some facts are there, I will clear it on Tuesday. I can say.
This matter was called up yesterday also.
Lordship,
This case was called yesterday also. Right, we'll give them one more chance. Yes, Mr. Goswami, what is your matter?
Well, at item 13 of the hearing list, but it's against an award of the labor court answering the reference under section 10 in favor of the workmen.
May not be possible today. Because I'm traveling tomorrow onwards.
The Lordship will take it up tomorrow.
I'm in outlying.
Oh,
bench.
I'm sorry.
Next week,
Very well, madam.
next week. Because after hearing, I may not be able to deliver the judgment.
Madam,
Next week,
we'll try next week.
next week. You are there, Mr. Das, you are there?
Yes. other side. This was the workmen.
Next week will.
Next week.